I'm praying for inclusion of the GA in the list, my lord.
For what?
My lord, for hearing, because my lord,
For what the GA?
my lord, the GA is with regard to, my lord, certain purchasers of a property, my lord, the development agreement of which was executed by the deceased, in respect of whom, my lord, the probate letters of administration application was taken out. My lord, in connection with the same, there were other two GAs which was disposed of by my lord's judgment dated, my lord.
This is the matter, Mr.
Mr. Dutt appeared, my lord. Yes, my
the
lord.
matter.
Yes.
Yes.
I'm grateful, my lord.
My lord, item number 91 of your lordship's commercial daily list. My lord, lordship has passed several directions for discovery and inspection of documents.
19.
91, my lord.
91. Today's list.
Yes, my lord. My lord, thrice over, lordship, your lordship has enlarged the time for the defendants to disclose their documents and file their affidavit of documents, my lord. They could not be taken out an application for striking out their defense. Your lordship had kept the application pending because they had assured us that they will try and comply with your lordship's order. My lord, till date, they have not disclosed their documents nor filed their affidavit of documents. Or framed
the commercial, no?
Commercial matter, my lord.
My lord, may I be permitted to mention PLA 283 of 2023 if your lordship takes this order of November 14, 2024, my lord, as otherwise not desirous of mentioning this matter, my lord. On November 14, 2024, your lordship had pleased to direct the department to grant probate. My lord, we have written to the department 6 times since then, my lord. We have approached the department, and last we have been instructed that it will still take 1 to 2 more months to draw up and complete the probate. My lord, kindly it's November 2024. I'll leave it to your lordship, my lord. I will not press this, but perhaps, my lord, some
registrar को भेजो, हम भेजा.
My lord, may I be permitted to mention item number 121 of today's list, my lord. My lord, the only it's a PLA matter, my lord, non-contentious, my lord. The only difficulty is there were 2 attesting witnesses. One has expired, the other one is not available. There is one attending witness who has filed an affidavit, my lord. She is around 70 years old. She is suffering from several ailments. But if any eventuality happens, the entire application will become infractuous, my lord.
What you want?
As per my lord's convenience,
I
any
don't
date
think-
can be.
I don't think from Monday my determination will be there in the testamentary.
My lord, I'm mentioning it. My lord, if it remains, my lord, kindly give some precedence, my lord. That's my only humble submission. That is my lord will pardon me for mentioning it. But my lord, I am also in a very precarious situation. 121.
Find permission, if I may be permitted to mention. Lordship, it's in item number 79 and 80 of your commercial list today's. Lordship, on the last occasion, the parties had agreed that according to section 89 of CPC, they will get into arbitration. An agreement has been filed. If your lordship may...
Party ready?
Both parties, it is signed.
Tuesday to be mentioned.
Grateful.
I'm appearing on behalf of the plaintiff.
GA is allowed. The added defendant has been struck off.
I'm sorry.
I appear for the defendant matter.
Could I appear?
With an earlier order whereby I was
Where is the written statement?
Yes, we have filed in the department.
Well, that's why there is no report. There is a report. There is no written statement. That's why I put the
No, my lord, we
matter.
have filed.
The copy has not been served on me.
That's
No,
why.
my lord,
I find Supreme Court after getting
Yes,
the
yes.
order of the Supreme Court. Then I asked the department to. They have submitted. There is no written statement. Where is the written statement?
No, we have filed it yesterday, my lord.
Where?
But in the department.
Okay, I am calling the report. You have not served the copy.
My lord, it was part of the application. That's why we will serve.
One more.
Record and not.
One more submission, my lord. I have preferred a review from that order, my lord.
Okay, whatever it may be, but the court has to go. The matter is listed.
Similarly, my lord, I am for the defendant number 5, my lord. I have also filed my written statement in the department yesterday.
Defendant number 5 perhaps cannot find.
So suffering for the matter is listed as to be mentioned on receipt of the report from the office, as the office has placed the order passed by the Honorable Supreme Court in Civil Appeal number 2753 of 2025, dated 14th February 2025. Full stop. Counsel for the defendant number 1. You have called
1 to 4.
defendant number 1 to 4 and counsel for the defendant number 5 submit that they have filed the written statement in the department. But written statement is not in record. Accordingly, the department is directed to place the written statement of the defendant before this court. Place the matter on Tuesday under the same heading.
In item number 3, my lord, I am for the plaintiff, my lord.
Yes.
But while mentioning the matter,
Why mention?
we have mentioned the matter because, my lord, the defendant, despite having received the writ of summons, my lord, has not entered appearance, my lord, and we have obtained.
I am appearing for the defendant, my lord.
Have you
May I be
obtained
permitted?
report?
Yes, my lord. This is the report, my lord.
My lord, I had mentioned the matter on the previous occasion, my lord, to take inspection of, my lord, how the writ of summons have been served.
This is
Now, as it seems, my lord, it has been served at a place where I do not reside. It is in someone else's occupation. And one place also, my lord, is there where the bank is occupying pursuant to SARFACI measures, my lord. So I have made ready the application, and your lordship will test this point, my lord, whether, my lord, it is deemed to be a sufficient
my
service
lord,
or
I will
not.
see the second paragraph of the report, my lord. It was served through court, my lord.
Only one defendant? Two defendants?
Defendants, my lord.
Two defendants?
Yes, my lord.
Yes.
Both were served through court, my lord. District Court, Paschim Bardhaman, my lord. And there is an forwarding letter from the judge in charge of the civil court of Durgapur, my lord. And this is also a report from the deputy registrar, my lord, original side, saying that the defendant had not entered appearance, my lord.
No, there is no dispute as to that, my lord. The only thing is whether I have received the summons, my lord, when someone else is in possession of the premises. Now, this issue, my lord, needs to be tested before your lordship. I am filing my application.
Okay.
Yes.
When it was served in the month of May 2024. We are in the 2025. So
Yes.
I am fixing and in the list of undefended, your application will come. You saw the copy. I will.
Yes. Yes.
Correct.
Yes. The only thing, my lord, can it be fixed, my lord, a week hence, my lord, only.
No problem. It will go long. In the meantime, whatever it may be.
I will take steps, my lord. Yes.
So and so appearing for the plaintiff. So and so appearing for the defendant. Both. You are appearing for both.
For both, my lord. For both. Yes.
Defendants. Full stop. Counsel for the plaintiff has handed over the service report dated 25th of June 2024, issued by the Deputy Sheriff of Calcutta, wherein it reveals that the writ of summons upon the defendants have been served on 11th of June 2024. Full stop. The counsel for the plaintiff has also handed over the report issued by the Deputy Registrar Legal dated 10th of January 2025, wherein it reveals that the defendants have not entered appearance either in person or through advocate till 10th of January 2025. Let the copy of both the orders be kept with the record. Learned Advocate, Mr.
My lord.
Learned Advocate appearing for the defendant submits that they filed or you are going to file?
We are going to file. I will file it by next week.
Defendants submit that they are going to file. The defendants are going to file an application for appropriate order on the ground that the writ of summons has not been served upon the defendants. Full stop. Whatever, full stop. This court find that at present there is no application on record on behalf of the defendant, either for extension of time to file written statement or any prayer. Thus, on the basis of the report submitted by the placed by the learned counsel for the plaintiff, this court find that the writ of summons was served upon the defendants on 11th of June 2024, but the defendants have neither entered appearance nor have filed written statement. Accordingly, CS Com 540 of 2024 within bracket old CS number 172 of 2023 be placed in the list of undefended suit. Please the matter.
Lord.
On 22nd.
If it would be your lordship's pleasure to appoint a commissioner so that
No, no. Now the defendant wanted to let I am fixing after next 20 time. If any application will come, I will see. Otherwise, I will place the matter in the witness section.
My lord, only thing, my lord, I had mentioned for the purpose of getting a copy of whatever has been handed over to your lordship today, my lord, so that the plaintiff can give me a copy of the report of service.
Is there the someone was served on the
I'll only take, if I may be allowed to take inspection of the same.
The report be kept with the record. List the matter on 22nd April.
22nd.
May I be allowed to take inspection of the same, my lord?
But you're not having the wakalatnama. You not file the wakalatnama. File wakalatnama, cam I will allow.
Yes. I will mention it upon filing the wakalatnama. Yes.
On May 22nd.
22nd April.
Grateful.
Independent. In the list of independent.
I am for the plaintiff. My lord, some corrections are there. Your lordship has already, my lord, laid down that if corrections are there, my lord, we have to reaffirm, and reaffirmation cannot be without your lordship's, my lord, restatement. Statement of truth, there are few corrections, and my lord.
You all seniors, or why you not taking with the department? Department only has to see the defects of the procedural defects.
Yes.
Can the department go with the contents of the plain?
My lord, I am obliged that your lordship is taking all this up. Today, the scenario is this: I am told that they actually go through an application and suggest that you cannot file this application.
That's problem. I have find.
How is it possible?
Don't know you. That's what I'm telling you. All senior persons.
Somebody told me that this has been told. I said, please tell me the name. Then thereafter, no objection was raised. Then the seniors has to put their foot down. Because otherwise, that's the only way to protect this side.
It's difficult. Everything is coming to the court.
How is it possible?
Affidavit is not correct. Affidavit is not correct. Only the procedural aspect has to be seen by the department during the scrutiny.
Absolutely, absolutely. I couldn't agree.
Suffering for the
Appear for the pro forma response. HDFC Bank.
suffering for the performa defendant. Police stop.
My lord, I am appearing for defendant number 2, my lord, National Bank.
Suffering for the defendant number 2. Police. The matter is listed as to be mentioned on receipt of the report from the department. It is fine from the report. There are altogether 6 defects have been pointed out. Police. The counsel for the plaintiff prays for time to cure the defects. The plaintiff counsel for the plaintiff also prays for leave to re-verify and reaffirm the affidavit of the plaintiff. In view of the submission made by the counsel for the plaintiff, 2 weeks.
But 2 weeks lands us within that April 10 to 3 weeks, if it's possible.
In view of the submission made by the counsel for the 3 fixed time is granted to the plaintiff to rectify the defects and to re-verify and reaffirm the affidavit of the plaintiff. Next.
Lordship, it's the same. Plaintiff is the same.
Same.
Defects I appeal think are the same.
Same order. 3 weeks with the liberty with the leave to file to re-verify and reaffirm the affidavit.
Great.
I am opposing this application, my lord.
My lord, this is an application for extension. It was filed within the time, my lord. It expired on 25th March.
What is the application for?
That is for extension for time for filing written statement. Written statement has been duly filed on
26th of November, writ of summons was served. My lord, they have filed on 18th of March. They have affirmed the written statement on 18th of March, obtained a leave of this honorable court on 21st of March, my lord. My lord, only fact is, my lord, if my lord goes to the affidavit, no delay has been explained, my lord. Apart from one paragraph, that is, it is a PSU company, it took time to collect the document. Apart from that, no explanation has been given, my lord. My lord, will remember on the last Friday, my lord, I was facing similar application, my lord. I am carrying that judgment where this honorable court was pleased to observe that the court is to see that whether I have explained the delay or not. My lord, I am not going to file any opposition, my lord, because already 1.5 years has passed since filing of the suit because it took so much time to scrutinize the document. My client is suffering a lot, my lord, but I'm heavily opposing this application. My lord, this should be dismissed. That is my prayer.
My lord, only one thing, my lord. In this particular case, the Kolkata Regional Office It's in the helm of affairs of the divisions, my lord.
Yeah?
So helm of affairs of the other divisions throughout the West Bengal. Now this pertains to the policy pertains to always a division. My lord, whenever the summon is placed to the division, it was sent to the regional office, my lord. And what are the technicalities when the documents are procured, the surveyor is consulted, and thereafter it is coming to the table, my lord. So the opinion of the advocates are taken, my lord. I have not described in details all the day-to-day thing, my lord, as my learned friend has stated. My lord, I have stated that this is the situations, the procedural delay, my lord. The clandestine theory, my lord, may not be adopted. This is my prayer. My lord, subject to cost your lordships, please allow the application. The written statement has been filed. I don't think it will delay the proceeding any further, my lord. That is the only prayer, because I cannot explain more than each day-to-day delay, my lord.
Yes.
That is the, I'm very, I mean, very frankly, I'm stating, because it will heavy the petition itself, because one day thereafter, then what are the documents, everything, my lord, comes. So I'm making this only submissions, my lord. There are technical situations for which it was prepared, and thereafter there are lots of volumes. If your lordships can see this, these are the volumes of documents, those are collected and filed, my lord. Because after that I cannot take the pleas of filing the fresh, because in sometimes your lordships has seen that whenever during an evidence, taking of evidence, fresh documents are being, that delays the procedure.
Yes.
But here in this case, my lord, what I have done, that I have applied that all the documents must come before this honorable court, and it could be filed within the due time, my lord.
Whether you file the written statement?
Yes, yes.
When you file, when you receive the writ of summons?
We took the leave of this honorable.
When you receive the writ of summons?
26th November.
26th November.
Yes. It expires on 25th of March.
25th of March.
Yes. And it was affirmed on 18th March. It was filed on 21st March, taking the leave of this honorable court, my lord.
Okay. Yes, madam.
My lord, my only submission is that this cannot be a standard, my lord.
Okay.
My lord, all the document that they have relied, my plain contains 11, 12 volume. All the submission that my learned friend has made, not on the record, my lord. This has come from the bar, my lord. All the document that they have relied are annexed to my plain, my lord. Those are not any new document that has been surfaced, my lord, today. So, my lord, all the submission that my learned friend just now made, my lord, this doesn't reflect from the written set the application, my lord. My lord, this should be, my lord, this cannot be standard, my lord. If in that is if just a PSU and then one date, my lord, then this is going to be the practice, my lord.
But this court is facing difficulties. If this court will dismiss the application, then the appellate court will set aside my order and remand the back. Or if the appeal court also upheld my order, the Supreme, just morning I got one order.
Then I leave it to your lordship. I understand, my lord, what my lordship is saying.
My lord, I'm not bringing up the new documents, fresh document at the time of the evidence, my lord. That even is happening.
My lord, I am paying for a heavy cost, my lord.
So and so offering for the plaintiff, so and so offering for the defendant. The plaintiff, the defendant has filed the present application being GA Com 2 of 2025, praying for extension of time to file written statement. Counsel for the defendant submit that writ of summons was served upon the defendant on 26th of November 2024, and the defendant entered appearance on 5th of December 2024. Full stop. It is submitted that after receipt of the writ of summons by the regional office of the defendant, immediately the defendant has engaged the advocate and held conference with the senior advocate. And pursuant to the advice of the advocate, the regional office of the defendant had started collecting necessary documents in connection with the suit to deal with the averments made in the plaint. Full stop. He submits that in process of collection the documents, it took some time. And as such, the defendant could not file the written statement within a period of 30 days. Subsequently, on receipt of all the documents, the defendant has drafted the written statement, and it was sent to the head office for approval. And after at, at, at the time of and after getting the approval, the plaintiff, the defendant has affirmed the written statement on 25th of March. When you
18th of
affirm
March.
18th of March
18th of March.
2025, and with the leave of this court, the written statement was filed on
21st March.
21st of March 2025. Counsel for the defendant submit that though the defendant has not filed the written statement within a period of 30 days, but has filed the written statement with the leave of the court subject to acceptance by this court within the outer period of 120 days. Counsel for the plaintiff submit that. Counsel for the defendant submit that. And then per contra, learned advocate appearing for the plaintiff raised a strong objection and submitted that the defendant has not shown any cause in the present application as to why the defendant has not filed the written statement within the prescribed period of 30 days. Counsel for the plaintiff further submit that the defendants have taken the stand that they have took time to search the document, but the plaintiff has disclosed all the documents, and the same was served upon the plaintiff, served upon the defendant along with the plaintiff. And as such, the stand taken by the defendant cannot be said that the defendant has taken time to search the document, though the document was very much available with the defendant. Full stop. Counsel for the plaintiff submit that this is the commercial suit, and the defendant has to file the written statement within a period of 30 days, but the defendant has failed to file the written statement within the period of 30 days and also failed to explain why the delay has been caused, and such the application filed by the defendant is required to be dismissed. Had the learned counsel for the respective parties peruse the pleadings and the documents. This court find that the writ of summons was served upon the defendant on 26th of November 2024, and the defendant has entered appearance on 5th of December 20. When you entered appearance?
25th, my lord. 5th December.
5th of December 2024. 26th received, 25th of December 2024. Full stop. The specific defense taken by the defendant that on this is a specific defense taken by the defendant that on after receipt of the summons, immediately the defendant has engaged the lawyer and held conference with the senior advocate. As per the advice of the advocate, the defendant had started search of the document. Some of the documents were with the head office, and as such, it took time to collect all the documents, due to which the defendant could not file the written statement within the period of 30 days, but the defendants have filed the written statement, affirmed the written statement and filed the same within the outer period of 120 days. Full stop. It is fine from the record that the defendant has relied upon several documents. The plaintiff has made the insurance claim against the defendant. The case made out by the plaintiff is based upon the documents. The plaintiff is relying upon some documents, and defendants are relying upon some documents. Full stop. The defendants have also relying upon some documents. Full stop. It is the specific case of the defendant that the defendant took time to file the written statement, as the they took time to search the document file written to prepare the written statement. Considering the above, this court find that one opportunity should be given to this court find that though the defendant has not filed the written statement within a period of 30 days, but have filed the written statement within the outer period of 120 days, and as such, one opportunity should be given to the defendant, but subject to payment of cost of rupees 10,000 to the State Legal Service Authority within a week from date. Full stop. The department is directed to accept the written statement subject to scrutiny by the department. Full stop. The defendant is directed to serve the copy of the written statement along with the document to the plaintiff within. Have served?
I have already received. It is annexed with the
application
application.
itself.
Documents.
All documents.
क्या बोला? No, it is submitted that the plaintiff has already, defendant has already served the copy of the written statement to the plaintiff. Full. The defendant is directed to produce the evidence showing that the defendant has deposited the cost of rupees 10,000 to the State Legal Service Authority within a week from date.
Look, grant me 10 days, my lord. Because 2 days, 3 days,
Within 10
this will
days.
go.
एक week का जगह 10 days. ठीक है?
My lord.
GA number so and so disposed of.
अच्छा
It my lord, I'm for the plaintiff applicant. My lord, this is
Yes.
my application for chapter 13A.
Yeah.
My lord, this writ of summons has not been lodged yet. And there are some writ
You
of
are for the
summons.
plaintiff?
Yes, my lord. On the last occasion, I filed my affidavit of service. I have served upon the defendant both through physical service and also by email. But my lord, the problem is that the writ of summons has not been lodged. There are some defects. We are in the process of curing it. My lord, we have to also extend the time for.
So what you want?
The case may be adjourned for 4 weeks, my lord.
As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the
Within 4 weeks, we will complete all.
Let the matter appear on 29th of April.
Deeply obliged.
Next.
I'm appearing for the plaintiff in this matter.
Yeah.
Well, this is my suit for recovery of money for which there is an admitted admission on the part of the respondent. My lord, I had already taken out an application for injunction and for judgment upon attachment. My lord,
Judgment upon
attachment upon attachment before judgment. My lord, my lord had already directed injunction which is subsisting. My lord had directed security to be furnished to the registrar. This order was passed back in September 2024, which has not been complied till date. And thereafter, my lord, on the basis of the affidavit in opposition filed by the respondent in the application, the GA1, my lord, I have taken out an application for judgment upon admission 12-6 under order 12-6. My lord, that application, my lord, on the last occasion, my lord, directed the affidavits to be filed, but no affidavit has been filed. So, my lord, today, if my lord permits, I can proceed on the basis of the affidavit in opposition that has been filed with regard to the application for GA1, which is the application for injunction, confirmation of the injunction, and the judgment.
Mr. Shomu Basu is appearing in this matter, is suffering from severe jaundice, my lord. So he is not appearing.
File an application along with the jaundice application, jaundice document for revocation of the order. I am hearing and passing an order. The jaundice, there is no medicine.
And my lord, we have filed the opposition, my lord.
Is there any medicine of the jaundice?
No, I have.
You have no idea. Your advocate has not informed you what medicine is taking for the medicine for the jaundice?
No, my lord.
Yes. Where is your affidavit?
I have
My lord, affidavit in GA1 was filed. Affidavit insofar as GA2 has not been filed.
2 weeks from date. 2 weeks is 28 February. Now we are on March last.
I am not. I'm just instructed to take.
He has not appeared on the last occasion. Also, his name is not there. None appears on behalf of the defendant.
Just praying for your week's adjournment. On the next week, he will appear and provide the affidavit. He's suffering from jaundice and he's bedridden right now.
But the only predicament is because there's an application for judgment upon admission. My lord, I will not, and this is the first occasion where an extension is sought. My lord, I will not come in the way if my lord keeps it after a week. My lord, may
come on the next week.
Yes, my lord. My lord may extend the interim order. It is
till 4th April.
4th of April. My lord, 4th of April it is valid till, and my lord, there must be some direction with regard to the secured order for security which has not been deposited. If my lord may seek a report if it has been submitted or not. My lord, admittedly, to my knowledge, there is no such order. Well, this was passed in September 2024.
With date?
My lord, may
30th August, my lord.
My lord, with regard to the
30th August
80 lakhs deposit, my lord, we have already paid them 26 lakhs and 33, 35, 30 lakhs is still stuck with the customs department. Once we get it clearance from the customs department, we will pay that.
My lord, the present suit was predicament on the fact that from the customs department they have received 72 lakhs, out of which 32 lakhs is with Standard Chartered Bank. My lord recollects we had sought leave under clause 12A and my lord had granted that leave. So that amount is still lying with the bank.
Suffering for the plaintiff, suffering for the defendant. Counsel for the defendant submit prays for time. Police counsel for the plaintiff submitted by an order dated 30th August 2024. This court has directed the defendant to furnish security deposit of an amount of rupees 80 lakhs with the registrar, original side of this court within 2 weeks from date. With this 2 weeks from the date of receipt of the copy of this order. Full stop. Counsel for the plaintiff submitted the copy of the order has been received by the defendant, but till date the defendant has not furnished the security of rupees 80 lakhs as directed by this court. Accordingly, the registrar original side of this court is directed to submit report whether any amount in terms of the order dated 30th August 2024 is deposited by the defendant or not. Let the report be filed within. Let the report be filed on or before 8th of April 2025. Full stop. Counsel for the plaintiff submit the interim order filed earlier is going to be expired on 4th of April 2025. Accordingly, prays for extension of time. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 11th April 2025 or until further order, whichever is earlier. List the matter on 8th April.
This is my application at the instance of defendant, Milord, for extension of Milord time to file written statement. Pursuant to your lordship's, Milord, I have received Milord writ of summons from 29th of November, Milord.
29 number you received?
Received, Milord. Pursuant to your lordship's leave, Milord, we have filed the written statement in the department on 24th of March.
24th of March.
Milord, the time will expire today, that is 28th of March, Milord, the 122.
I'm for the plaintiff, your lordship. I am objecting to the written statement, your lordship, and as well as the no list of documents has been filed by them. Only I have received a written statement along with this statement of truth. No list of documents has been filed by my learned friend.
Milord, we have filed it, Milord. We have served, Milord, the written statement and statement of truth. List of documents has been filed in the department. I shall serve a copy. I have a copy, Milord. Milord, my explanation, your lordship will find.
What is the other objection?
I'm praying for cost, your lordship, on the admission of their written statement.
That's all.
Milord, that is, Milord, the suit, Milord, itself, Milord, pertains to the monetary transaction, Milord, in 2016 and 17. And Milord,
so how 16-17 you filed the suit in 2024?
Milord, that is they have done, Milord. We have a point of limitation in the written statement itself, Milord. And Milord, admittedly,
that is not the ground to extend the time.
No, Milord, no. What is, Milord, my explanation is, Milord, that admittedly, Milord, the work was carried out in Haldia. I have a registered office in Kolkata, Milord, but that is why the suit has been filed here. But all transaction, all work has been done in Haldia. After we received, Milord, we had to send it to the Haldia, Milord, after their response, and in between, Milord, has taken the time, Milord, because it's, Milord, the commercial team has to, Milord, given an opinion. That is my explanation, Milord, and we have filed, Milord, pursuant to lordshiply within 120 days. The explanation will lordship will find, Milord, from paragraph 3 onwards, Milord. And it has been affirmed on 21st of March.
So suffering for the plaintiff, so suffering for the defendant. The defendant, sole defendant?
Yes,
yes, your lordship.
The defendant has filed the present application being GA-1 of 2025, praying for extension of time to file written statement. Counsel for the defendant submitted. The defendant has received the writ of summons on 29th of November 2024.
Copy of the
2024. But the defendant could not file the written statement within a period of 30 days on the ground that after receipt of the written statement, after receipt of the writ of summons, the plaintiff has approached the legal department of the defendant company as the issue involved in the present suit filed by the plaintiff is with regard to supply of construction materials at Haldia, and the matter relate back to the 2016 and 2017, and as such the defendant took time to search the document which is of the year 2016-2017. After getting the documents, getting the documents, the defendant has drafted the written statement, but in the meantime, the 30 days period for filing the written statement was over. But subsequently, the defendant has affirmed the written statement and served the copy of the same to the plaintiff, and with the leave of this court, the defendant has filed the written statement on
24th of March
2025, that is within the outer period of 120 days. Full stop. Learned counsel for the plaintiff raised objection and submits that the writ of summons was served upon the defendant on 29th of November 2024. But the plaintiff has not assigned any reason as to why the defendant could not file the written statement within the period of 30 days. Full stop. Counsel for the plaintiff further raised objection that the written statement which the defendant has filed only contain the statement, truth and list of document, but the document has not been served. Full stop. Counsel for the plaintiff raised for rejection of the application filed by the plaintiff for extension of time to file written statement. Had the learned counsel for the respective parties, this court finds that after receipt of the writ of summons, the defendant has diligently started searching the document. It is true that the matter related to the year 2016-2017, and the place of work of Haldia, which is far away from the head office of the defendant. Full stop. It is the specific case of the defendant that due to the search of the old document, the time period of 30 days was over. But admittedly, the defendant has affirmed the written statement and filed the written statement with the leave of this court within the outer period of 120 days after serving the copy to the learned counsel for the plaintiff. Full stop. The counsel for the defendant submitted, though the defendant has served the written statement along with all the document, but if the plaintiff submits that the document is not been served, the defendant submits that they will supply the document relied by the defendant. At the full stop. Considering the above, this court find that though the defendant has not filed the written statement within the period of 30 days, but has affirmed the written statement and filed the same in the department with the leave of the court within the outer period of 120 days. And as such, this court is of the view one opportunity should be given to the defendant to file written statement, subject to payment of cost of rupees 10,000 to the State Legal Service Authority within 10 days from this.
I'm grateful, Your Lordship.
The defendant is directed, police of the department is directed to accept the written statement subject to scrutiny. So the document.
My lord, I shall serve it. I have one copy. My lord, only the list of documents.
Defendant is directed to serve this list of documents, serve the documents relied by the defendant in the written statement.
My lord, may I just indicate written statement? My lord, I have annexed the document. My lord, I have only the list of documents
within a period of 10 days from date.
That
I'm grateful.
The defendant is directed to produce the evidence to show that within a week, within 10 days, to show that the defendant has paid the cost to the State Legal Service Authority.
Grateful.
Grateful. My lord, I am for the petitioner defendant. These are my applications for revocation of leave.
Yes.
Return of plaint. Despite another opportunity, the plaintiff has still not filed any affidavit in opposition.
My lord,
I am ready to argue the matter.
My lord, I appear on behalf of the plaintiff, my lord. My lord, both of these applications are for revocation of the clause 12 leave and for rejection of plaint, my lord. It is I'll be very candid with your lordship, my lord. We are in your lordship's hand today, my lord. We have not been able to file our affidavit. There was an extension granted by your lordship for 2 weeks, and we have not filed it till date, my lord. The extension was last granted on 17th of February. 2 days have long expired, my lord. I'm led by Mr.
Default on our part, your lordship.
What? Not filing a written statement?
No, could not file the affidavit in opposition to the application.
When the order was passed?
The last order was passed on 17th of February. 2 weeks were granted, which expired.
17th of February. We are in March.
Yes.
March is going to be end. Yes.
Lordship, mistake on our part, your lordship. I cannot give any further.
How soon you will file?
Within 1 week.
1 week.
1 week, your lordship will file it.
I'll need 1 week to file my rejoinder, my lords. The issue, the sense of urgency, the underlying dispute is out of breach of contract. That contract has an exclusive jurisdiction clause, which has Gurgaon court. Now, I filed a suit in Gurgaon in which they filed an application for return of plaint in Gurgaon. Now, that application was rejected. They filed an appeal before the Honorable Punjab and Haryana High Court. There was a consent order in the Punjab and Haryana High Court saying that the Gurgaon suit can proceed. So, as of now, there is really no reason to continue with this suit, which is why there's a sense of urgency. My lords may have it in April.
That's my, I am not appearing before that particular court, but that's my instruction.
Out of the same cause of action is that.
That's my instruction, your lordship, that we have not given any consent. And your lordship
I'll show
was,
that, my lords.
No, but if the Punjab and Haryana, before the civil court or commercial court?
Commercial court.
Before the commercial court, if your Order 7 Rule 11 or Order 7 Rule 10 is rejected,
their Order 7 Rule 10
but the appeal is still pending.
No, the appeal has been rejected. There's a consent order.
Okay, let us bring all this.
Yes.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the plaintiff prays for extension of time to file affidavit in opposition. Let affidavit in opposition filed within a week, reply if any there to be filed within a week thereafter. List the matter. 22nd April.
My lords, my apologies. Can it be the 24th of April, my lords?
Then come on 25th.
25th, my lords.
25th.
In this matter, my lord, Mr. Moinak Bose was addressing, my lord. Mr. Moinak Bose was addressing, my lord, on behalf of defendants 6 and 7, my lord. Right now, my lord, he was waiting, my lord. He's gone out. There's an urgent matter before the my lord, division bench, my lord. He's just gone. Could, my lord, grant a 5-minute passover only. Just a 5 minutes. He'll be coming back, my lord.
Passover.
Apply.
Item 13 and 14, my lord, I am for the petitioner. My lord, it is an application under Order 9, Rule 13 for setting aside of an ex parte decree, my lord.
Who is for the other side?
I am here.
Yes.
Lord, may I file my affidavit in reply to their opposition? It has been served long. My lord, what happened in this matter?
What is the ground for setting aside?
My lord, the ground is that, my lord, the summons could not be served upon me, my lord. Because, my lord, if your lordship kindly first takes up my affidavit in reply once, my lord, the annexure, only one annexure is there. The reply that I have filed today. But this is an order.
J2?
Either of. J2 is the, my lord, Section 5 application. Either of both.
Yes.
My lord, page 12, my lord, annexure A.
Yes.
This is an order dated 15th April 2024, my lord. The matter is listed as to be mentioned on the prayer of such and such. Counsel for the plaintiff has handed over the service report issued by the Office of the Deputy Sheriff of Calcutta dated 14th March 2024, wherein it reveals that the copy of the writ of summons was returned as unserved, with the remark, defendant could not be found as he sold the property and moved. Counsel for the praise for direction for substituted service, etc. So, my lord, my house, which was situated at, my lord, Alipur, my lord, that was, my lord, taken by the bank under the SARFAESI Act, and therefore I have to move to Baguihati. And since, my lord, I have moved to Baguihati, my lord, the summons could not be served upon me. Obviously, my lord, thereafter, my lord, the substituted service was, my lord, affected, but, my lord, the newspaper, my lord, it slipped my lord, eyes, my lord. I cannot see.
What is the purpose of publication? Milord, that is a substitute, sir, with the last source. That is the last resource, Milord. That I Milord manage. But Milord, the point what I will argue, Milord, if your lordship kindly takes up, Milord, their opposition once. Your lordship, I have shown your lordship the order of 1st of April 2000. 15th April. 15th of April 2024. Yes. Now, Milord, if your lordship kindly takes up their opposition, Milord, your lordship will find their opposition to Milord J2. But how I have came to learn about the Milord this institution of suit, Milord, at page number 8, Milord, of their opposition, page number 8, opposition to J2, Milord. Milord, this is a memo of arrest, Milord. They have instituted a criminal complaint against me under section 138 of the Milord Negotiable Instrument Act, Milord, where I was apprehended. Lord, if your lordship, so this was within their knowledge, and your lordship will find that the arrest was made from, Milord, the address is mentioned there. In the Milord, from top, Milord, D, residential address, Milord, from where I was apprehended. Milord, this arrest, Milord, taken place on 28th of March 2024. So prior to the order of 15th of April, they were very much a party to this proceeding. They had the knowledge that I was apprehended from Milord Baguihati address, but this was never, Milord, brought before your lordship notice. So on the day when this honorable court has what is the address in the complaint under section 138? That address is also Milord Alipur address. Alipur address. Then Alipur, but Milord, I was arrested, Milord, from this address. See, in the criminal case, if a person is arrested, brought under arrest, the complainant will not go and see in which address you have been. The police might have been arrested while you are traveling, while you are in the fleeing away. That is true, Milord. But Milord, for if your lordship wants, Milord, take Milord order 9 rule 13, Milord, once. But I have a very good defense here because this company, Milord, is not even, Milord, as I have been instructed, registered under the RBI, Milord. This, Milord, the loan which was granted, Milord, kindly take, Milord, order 9 rule 13. In any case in which a decree is passed ex parte against the defendant, he may apply to the court by which the decree was passed for an order to set aside. And if he satisfied the court that the summons was not duly served, or that he was prevented by any sufficient cause from appearing when the suit was called on for hearing, the court shall make an order setting aside the decree as against him upon such terms as to cost payment into court or otherwise as it thinks fit, and shall appoint a day for proceeding with the suit, provided where the decree is such a nature cannot be satisfied. Is not the first part, Milord. So your lordship, Milord, to see, Milord, whether there is any sufficient cause. Milord, I am, Milord, giving emphasis to this expression, Milord, sufficient cause. Correct. Milord, no problem. So while deciding an order 9 rule 13, Milord, this honorable court has to see whether really I had knowledge or not. Milord, from the entire record, Milord, your lordship will not find a single document which indicates that I had the knowledge. And Milord, while paper publication, sir, Milord, that is true. That is the Times of India, and Milord, in that event, Milord, newspaper in that event, in the West Bengal. Milord, in that event, Milord, order 9 rule 13 could not have any meaning, because in all the suits, Milord, if the service is not served, Milord, it is done by substitute service. Correct. That is the common practice. Correct. Not common, Milord, practice. Yes. That is the law provided. That is the law provided. Not under order 5 rule 20. No, so order 5 rule 20, rule 20, it is to taken out from the CPC. I am not saying, because the paper publication is no value. So you can come at the any time and file an application under order rule 9 13, because you have changed the address and the paper, you have not gone through the paper publication. Milord, I am not, Milord, saying that, Milord. Milord, only thing, Milord, is that, Milord, in a order 9 rule 13, Milord, I have some cases to show that, Milord, the sufficient cause, the expression sufficient cause. So while sufficient cause. Milord, what is the sufficient? Your sufficient cause is the address change. Milord, I had no knowledge of the suit. What? How I have got the knowledge, Milord, that I have expressed, Milord. How, immediately after I have got the knowledge, Milord, I have taken steps. Have you initiated the this mediation process?
Yes, my lord, it did not appear.
It did not appear. Then
Milord,
It was served.
even
but
it was
did not appear.
then
no, it was not served, Milord. It was not, Milord.
That is report of the mediation, my lord.
correct.
That
It is a commercial suit.
It is a
mediation
commercial suit.
center.
Milord,
It is not that the leave was granted and they have proceeded the matter. They have initiated the mediation process. Notice was issued. You have
Milord,
not appeared.
even there, Milord, the same thing, Milord, happened, Milord. If your lordship kindly takes up my application GA number 3 once, Milord. But kindly see, Milord, what happened to me, Milord. I was under compelling circumstances. Kindly see, Milord. Milord, at
What
first,
is the
Milord,
amount? What is the amount?
1 crore something, my lord.
1
Then
crore
more than
my lord,
deposit. I am deposit.
Milord,
It will be.
Milord, kindly, Milord,
You deposit the 5 crore. It will be in the interest bearing account. And I will set aside
For-
the
Milord,
special procedure. If you won, you get the take the 5 crore along with the interest. If you lost it, they will get the 5 crore.
Milord, they don't have, Milord, any license to
So
give this, Milord, kind of loan, Milord, under
when you are
exorbitant.
when you are taking the loan,
Exorbitant-
you are taking
Milord,
the loan.
that
You
defense,
are
Milord,
not aware that the license is required or not. But you have taken the
today,
loan.
Milord, I am not disclosing my defense, but Milord, they are charge exorbitant, Milord, interest, everything, Milord. I will brought on record, Milord. Give me one chance, Milord. Give me one chance. Kindly see the compelling circumstances why I have to leave the house. It's not that I have left the house on my own, Milord. It was taken over by the bank at my page 18 of my, Milord, application, Milord, GA3. The bank has taken over my property, Milord.
So you
under
are
the
defaulted
SRPC Act.
defaulted in the bank. You are defaulted to the private parties.
Merely a person
Okay,
become, Milord, financially weak.
I appreciate you deposit the amount. How much? Tell I will set aside here in now.
Milord, I will come back with, Milord, authorities to show that, Milord, this reasonable cause, whenever used in any statute, Milord. Milord, little bit, Milord, this reasonable cause,
This
the court has to.
I am defining the sufficient cause in here in now.
Milord, Milord, sufficient in while defining, Milord, sufficient cause, Milord.
That's what I'm telling. Show me the what is the sufficient cause. You have argued the 2 point now. You have argued the 2 point. Your address was changed. Paper publication. You have not gone through the paper publication. These are the 2 causes you saw. That is not a sufficient cause.
Milord, kindly
if
see.
it is a sufficient cause, that the Order 5 Rule 20 is to be taken out from the CPC.
Milord, kindly see under what circumstances, Milord, the summons.
You are the defaulter in the bank. You are defaulted the private parties. Now you watch what is going on. When the decree is passed, now you come with that.
Milord, it was
this tax.
Milord,
this court knows for the last 3 years here. I am dealing with this matter.
In my application, Milord, I have given all the documents. How I have
given opportunity. Take the instruction from your client. Whatever the amount or what is the principal amount.
1 crore 16
1 crore
principal is that is with interest.
Okay.
What is the principal?
What is the principal?
Interest is 1 lakh.
What is the principal?
Principal is 1 crore 58.
Deposited.
That is with interest it comes.
No, 1 crore 16 lakh you deposited with the interest bearing fixed deposit. I am setting aside.
Milord, before that, not kindly see the documents. Milord, I have explained how it is not that I have straightway come before your lordship that suddenly Milord, page 18, Milord, is the bank's, Milord, surface notice.
This
Milord.
is not a sufficient.
Yes.
This is your default.
Position notice.
Correct, no problem.
Position was taken.
No
Milord,
problem.
how I came to know about the, Milord, shoot, Milord, that I have also annexed. Milord, kindly see, Milord, page, Milord, 48. Page 48 of the, yes, Milord.
Of the
Milord, GA3. Of GA3, Milord. That is the application, Milord. Milord, the suit was decreed, Milord, ex parte.
Yes.
On, Milord, on, Milord, 27th of August 2024, Milord.
Yes.
And thereafter, Milord, again, Milord, this order was, Milord, corrected on, Milord, 6th of December 2024.
Yes.
Now, Milord, kindly see, this is the petition, Milord, which they had filed before the Bankshal Court, Milord, for recalling of my bail. And in this petition, Milord, for the first time, it was disclosed that I came to learn from this petition, Milord. Therefore, I have annexed this, Milord, paragraph 6.
Yes.
From this, Milord, it is stated that in the meantime, the complainant had a civil suit bearing such and such number, CS number such and such. The Honorable High Court Calcutta, even where the accused, Mr. Such and such Ghosh, could not found despite of summons such and such. And therefore, this disclosure from CS 238. Immediately I have got this, my lord, I have taken steps.
So when this application was served to you?
My lord, this application was served, my lord, if your lordship kindly see, my lord, on the page 48, my lord, it was received on 11/9/2024.
Correct.
But the next date, my lord, which was fixed before the court.
No, that is served to you when the application was filed before
that
the
is
court.
what I am
December.
coming. That is what I am coming, my lord.
December.
My lord, in December it was filed, my lord.
September you came to know, December. Again the 30 days is over, 90 days is over.
My lord, the question of 30 days, my lord, may not come in the way, my lord. This is my respect to subject to correction by your lordship. Because, my lord, the order has been, my lord, if your lordship kindly takes page 60, my lord. Page 60.
Yes.
Lord, therefore, on 6th of December, my lord, the order was corrected. And my lord, I have disclosed.
That is different thing. You came to know with regard to the suit on September 11 September.
My knowledge, my lord, I have specifically averted in the petition, my lord. I have got the knowledge on 28th of November 2024 when I was holding a conference in respect of this matter. My lord, at my lord, para 7.
So 11 September, what would be the 11 September you received?
Lord, that was received by my lawyer, my lord.
Then?
Thereafter, my lord.
Your lawyer might have been received.
Immediately before.
Sorry.
My lord, that was a 30 days. My lord,
sorry.
My lord, kindly let
the evidence which you produced in the document itself is wrong, sir.
My lord, it is 24, my lord.
I am again giving the time. You want to deposit the amount, I am allowing.
My lord, in that event, my lord, kindly keep it in the next Friday, my lord. Let me take instruction, my lord.
Otherwise, there is no merit in your application. You got the application which they have disclosed the civil suit in September. You file this application in December. That is also after 90 days.
My lord, a bunch of paper was handed over to the lawyer.
So,
I have hold a
all the sufficient causes go in your favor.
Only 1 month, my lord.
Sorry.
My lord, kindly take me instruction, my lord. I will take instruction on the deposit issue, my lord. If your lordship kindly give some liberty to only the principal amount.
That's why I'm telling principal 1.16 lakh.
1.16.
1 crore 16 lakh. You are ready to deposit with the registrar original set. I will not allow the plaintiff to withdraw the amount. That let it be continue in the interest bearing account.
Mainly kindly take out the matter, my lord, on the next Friday, my lord. I will come up with the instruction and will allow also me, lord, if I can show some case laws.
I will not. On merit, if you want to argue, then I am passing the order herein now.
Let me take instruction.
Only with regard to instruction. So appearing for the plaintiff, so appearing for the defendant. The defendant has filed the present application being GA3, GA-3 of 2024, praying for setting aside the ex parte judgment and decree passed by this court dated 27th of August 2024, which was subsequently corrected by an order dated 6th of December 2024. Full stop. After hearing the counsel for the plaintiff has argued, counsel for the defendant has argued the matter at length, and this court was not satisfied. Accordingly, counsel for the defendant has prayed for time only to take instruction. In view of the submission made by the counsel for the plaintiff defendant, the case is adjourned. Let the matter appear on 4th of April 2025. The same heading.
Lord, the affidavit in reply, Lord, kept on. Lord, affidavit in reply has been filed, may be kept.
Affidavit in reply filed by the defendant be kept in the record.
Lordship, the next matter, the matter which is not fixed, your Lordship. Item number 15.
This is a revocation of patent, if your Lordship recalls. My lord, I was arguing regarding that ferric carboxy maltose, if your Lordship recalls. My lord, we were to file a supplementary affidavit. Lordship granted us leave to file a supplementary affidavit. My lord, we have served the supplementary affidavit delayed. Delayed. We have served the supplementary affidavit.
Delayed. Your Lordship, I have received on yesterday.
Lordship, I appear for the Assistant Controller of Patents, your Lordship. I have not received a copy of the supplementary affidavit.
But I am for the main respondent.
Number 1.
What has happened to the appeal?
Appeal is still pending. But in that's a different. That was on the suit, my lord. That was my learned friend suit, my lord. We filed 2 revocation applications for patent. This is one of the revocation applications, and your Lordship heard it. And your Lordship granted our liberty because we wanted to bring certain other documents on record. My lord, we have handed over the copy. My lord, to my learned friend, your Lordship had directed Mr. Singhania, but Mr. Singhania has returned the brief. Therefore, we'll serve my learned friend, the respondent number 2, in the course of the day.
Very
I
well.
am for respondent 1. I
I'm
want
great.
to respond to the supplementary because new documents have
Yes,
been
yes,
disclosed.
yes. So when you will file?
My lord, I'll file it. I have received
Ready?
a copy. Yes.
Serve the copy.
I've served it to my learned friend, Mr. Dasgupta. I'll serve it to my learned friend appearing for the respondent number 2 in the course of the day.
So appearing for the petitioner. So appearing for the respondent number 1. And so appearing for the respondent number 2. Counsel for the petitioner has filed supplementary affidavit after serving the copy to the learned counsel for the respondents. Let the supplementary affidavit be kept in the record. You will deal with that document supplementary.
I want to deal with the
Counsel
supplementary
for the
once it's
respondents
served to me.
prays for time to file affidavit in opposition to the supplementary affidavit filed by the petitioner.
Your Lordship, since this is a reassigned brief, Your Lordship, I would also like to deal with the main petition, Your Lordship.
Deal with the
main petition, my lord, because they haven't served, they haven't filed any opposition.
Supplementary affidavit. Petition. The counsel for the respondent number 2 also prays for time to file affidavit in opposition to the main application.
Yes, the main revocation application.
As well as the supplementary.
Main revocation application. Accordingly, the respondents are directed to file their affidavit in opposition, and the respondent number 1 is given liberty to file affidavit in opposition to the supplementary affidavit within
Rejoinder to the supplementary because I've already filed an affidavit of opposition.
rejoinder to the supplementary affidavit within 2 weeks. Within
3
2
weeks. 3 weeks. Your Lordship, 3 weeks. Humble request, 3 weeks.
Your Lordship, since the department takes a lot of time and since this is a reassigned brief, Your Lordship, 4 weeks, I'm humbly requesting. Being realistic, Your
Is
Lordship.
granted liberty to file affidavit to the revocation application as well as to the supplementary application and affidavit within 4 weeks from date.
I'm so grateful.
Reply, if any, there to be filed
2 weeks.
within 2 weeks thereafter. No, 4 weeks, 2 weeks, 6 weeks.
It will be your lordship's pleasure to kindly fix the matter on some date.
Date then June I am fixing. Yes. In the meantime, you complete it.
Yes.
This is the matter on.
Deeply obliged.
But make sure the affidavit should be complete.
24th.
अभी आ जाएगा.
तो आगे दिन
24th June at 2 p.m.
Nothing before.
Grateful.
May it please, my lord. My lord, I appear for the defendants 1, 2, and 3.
Item 34.
44. The
commercial.
plaintiffs, my lord, have filed this suit alleging that the defendant number 1's husband, who was allegedly an employee of theirs, has transferred money from his account to the deceased account. He has died to his account. And they are saying that this was done in breach of trust, fraud, and by concealing these transactions. And after he died, they got hold of his computer and they have found out. Now, and your lordship has passed
that one.
Ad interim order granting an injunction on all the bank accounts of the wife and the immovable properties. Actually, three annexures were there. Your lordship has merely said not to dispose of the properties mentioned in annexures OP and M, or OP and N, I think, of which annexure O lists the insurance. So I had just given your lordship a broad overview of the matter on the last occasion. Now, if my lord allows me, if I may show the petition.
So injunction is respect of the N, O, and P.
Yes.
Annexure N, annexure O, and P.
So if my lord takes the petition, so I'll just summarize the points that I propose to make, my lord. First, I want to show that the plaintiff at this prima facie stage has failed to prove that the transactions were unauthorized. Well, the word unauthorized has been used 15 times in the petition and also in the plaint. No other word. It's just that these transactions are unauthorized. In the same breath, they have said that this, I'm just calling him the deceased, is the respondent number 1's husband. The deceased, my lord, was authorized to use the accounts because he had the mobile number was registered, was his, etc., etc. So in the first breath, he says that you have allowed one person to operate your bank account.
Yes.
This is his case.
Yes.
And you say that these transactions he has transferred to his own account. That's the only evidence they've shown, that not even the two bank statements, a statement from their bank saying that these monies were sent to the deceased's account.
Yes.
Now, if they had disclosed their entire bank statement, and that also this whole these transactions have been running from the year 2021 to 2024. Well, their bank statements have deliberately not been disclosed. So if their bank statement is disclosed, it would show there are many more transactions which they have not picked to say that these were unauthorized. Also, my lord, there is nothing to show today except that one entry here and one entry there, that these entries were done at the behest of the deceased and that he had not consented to that. So if the particulars of, if a case of fraud is to be made out, my lord, it has, your lordship knows, even in civil and criminal proceedings, it has to be beyond reasonable doubt eventually. Now it's the prima facie stage, but even now, my lord, the standard would be very high. So they will have to give particulars. They have pleaded some particulars, but that is just lip service, my lord, saying that this was done deceitfully, disguised, etc. Now they have to show that this transaction was not. Be that as it may, my lord, from the petition, on the basis of the petition, my lord had passed an ad interim order that these transactions appear to be unauthorized. In my affidavit opposition, we got hold of, as it is, the wife is not really aware of what is happening, whatever documents she could get hold of, that the husband used to get regularly commission from the plaintiff. Now, what this commission is for, we do not know. It's probably share broking, or it could be for other activities as well, my lord. This, my lord, was not revealed in the plaint at all. That I am entitled to get some payments the plaintiff has probably made. Then, in the reply, in order to cover this lacuna, they have said, yes, we used to pay him commission. Now, which was the transactions that were the commission and which were the ones that are unauthorized is still not clear before my lord. So, your lordship will have to keep this. Basic argument of mine will be that these are all tribal issues and they will have to be ascertained after trial. Now, this fact of that there were transactions between the deceased and the plaintiff, money was being put from one account to another, this was completely suppressed in the petition and at the time that the order was revealed. 842 so an email had been shown. Yeah. Yes, page 592 of volume 4. Page 592, volume 4. This was not there at all in the petition, plaint, or at the time when the ad interim order was sought.
Page 490.
Page 592, volume 4.
Yes.
Now this shows, this is the deceased writing to the plaintiff. Volume 4, affidavit and reply. 4 volumes of documents were disclosed in the reply, but we never, because the matter had been called only after argument started, we asked for opportunity to deal with this. But be that as it may, your lordship didn't permit it at that stage. But eventually in the suit, we will have to counter these documents. Our case cannot be made out by a supplementary affidavit or a reply. They have to stand and fall on the original. And in fact, my learned friend, Mr. Mukherjee, who argued the matter, placed only your lordship's order and said they really want confirmation of that order. So I am trying now to either have that order vacated or at least to modify it to the extent that the law permits. Now, my lord, 592. As discussed, this is the deceased is writing to the plaintiff As discussed, please find attached the final profit and loss report of share trading for 2023 to 24 and the year-to-year profit overall and accrued commission statement of myself. Then hope you find this in order. I will withdraw only in November. Then if my lord turns the page 593, here it says, at the bottom, my lord, after the net profit has been done, the statement of the shares traded for these particular years, all the years are given. KL commission, KL is Kirti Lunia, that's the deceased. Commission accrued 20% of net profit comes to 38 lakhs. Paid in 2020-21, 25 lakhs. Odd balance receivable, 12 lakhs.
Yes.
This is one offhand statement. Now, how many transactions there were, whether this covers everything or not, is not discussed. Now, during his submissions, Mr. Mukherjee conceded that this 25 lakhs 77 was paid, but it was said that we have not claimed this amount in the suit.
Yes.
But at least it's admitted that this amount was paid. There are transactions where money has come from the plaintiff's account to my husband's account, and that money, the details whereof, they have not produced. So at this stage, my lord, now this is one thing about the commission. I had referred this earlier, my lord.
So as per your submission, so this is 12,98,240.
The amount is irrelevant. It's the fact that commission was paid. This fact was suppressed from the petition. The amounts will come at the time of trial, whether I have a claim against him or not, that's a different matter. The amount is really irrelevant, but all these transactions that have happened, this was not stated in the plaint.
Instead, they say that he only earned salary, so how could he have so much
money? And impression was sought to be given. He's an accountant. I'll come to each of these facts, Manoj. He earns a basic salary, a lakh or etc. a month. And how could he have bought a flat, etc.? A lot have been said about their expenses, etc. So Manoj, this fact that there was a commission payable every year to my husband, that was suppressed. And this, your lordship will just make a note, page 98 of my affidavit in opposition, where he has also another WhatsApp from my husband to the page 98. I had shown this on the last occasion, but anyway, your lordship will see it. Really, so they have not really denied this, but we have touched gross profit of 206 lakhs.
98 of your
page 98 of AO, of the affidavit of Rani Lunia.
Yes.
Yes. So it's a printout of a WhatsApp message. We have touched gross profit of 206 lakhs till now in equity business. So there was some equity business going on between the two parts, the deceased and the plaintiff. Net interest is so much, and then target.
Kirti Lunia? Wife.
Kirti Lunia is the husband, the deceased husband. Rani is the wife. Rakhi, I'm sorry. Then target by 31st March is to reach 225 lakhs net interest, etc. The second last line, Manoj, is important. Even after my commission, your net retainage should be approximately 190 lakhs. So this is where I understood for the first time that he used to get commission. Now, the entire laptop and documents of Kirti, the deceased, is lying with them. They have disclosed my entire income tax accounts, even my income tax accounts and returns, balance sheets, etc. all have been disclosed in the affidavit in reply. Now, if my lord takes the volume 1 of page 35, volume 1, yeah. Yes. Now, if my lord takes volume 1 of their affidavit in reply, they have disclosed my balance sheet. And this balance sheet reveals there are monetary transactions between the plaintiff and the defendant right from 2021. If my lord comes to page 25.
Yes.
The balance sheet. This is surprising. Your lordship will see on the right side, loans and advances.
Yes.
Arvind Kumar Mehrotra. This is the plaintiff. I have given him loan for 25 lakhs.
Yes.
All this was not mentioned at the time of obtaining the interim order or in the plaint or in the petition. That there are money. Now, why an employee will give 25 lakhs loan and advance to his employer, we do not know. That will have to be proved. But these facts, now your lordship will see sundry debtors, high-tech air systems.
Yes.
Salary. This is the partnership firm that is referred to.
Yes.
Repairing something. So my sundry debtors, high-tech air systems. The plaintiff is a partner according to the plaintiff, paragraph 1. Well, we did some research on this. There is a company with the same name and the plaintiff is a director. But he has referred to it as a partnership firm. So whether that statement is correct or not, we will deal in the suit, my lord. But this high-tech air systems in any event is, I am to get, the deceased was to get salary of 57,500. So
Yes.
there was a debtor as that hadn't been paid.
Yes.
Then, my lord, the third company, Meho HCP Air Systems.
Yes.
This is also a company where the plaintiff is a director. So I am also owed money by that company, 78,164.
Yes.
Well, this fact was not there in the petition, so we could not deal with it in the reply. But we have taken out the ROC records. Your lordship can take it from me, that we will disclose it if necessary. That in both these, as far as the high-tech is concerned, it's admitted in the plaint. And even as Meho is concerned, Meho HCP Air Systems, it is the plaintiff's company.
Yes.
So here, these facts were not there before my lord. Page, that was 25. Now, if my lord comes for the next year, page 30. Now, it appears that Arvind's loan is no longer there. So, it has been paid. Page 30.
Yes.
So, some part of it, it was for 25 lakhs was Arvind's loan.
That is over.
No, your lordship.
28,000.
So that is over. That's not under the loans and advances. Now, high-tech has got 40 lakhs, has taken 40 lakhs from my husband. High-tech Air Systems, which is the partnership firm referred to in paragraph 1 of the petition and plaint.
Yes.
They have taken. And on the left side, my lord, it appears that Arvind Mehrotra has, now the deceased has taken a loan, unsecured loan of 20 lakhs.
Yes.
If my lord sees unsecured loans on the left-hand column.
Yes.
So somewhere in between, he must have paid him back his 25 lakhs and I have borrowed 20 lakhs from him. That's between the page 25 and page 30, the two balance sheets. So there are a lot of unexplained questions, my lord, which have to be gone into. And these were deliberately not brought to my lord's notice, that there were ongoing transactions. He himself has said he has authorized the deceased to operate his bank account. To what extent? Then he would have said, I've only told him he can buy shares in this company, or he has given instructions, or he has shown a contract. Much was said about the fiduciary duty, etc. But where's the contract? There is no written employment. Was it to be understood that he was a friend of his, that he was doing this, or was he doing it for free? There's no salary from Arvind Kumar Mehrotra, at least reflected. The company is giving a loan. I am giving a loan to the company. So these entries will have to be, I'm again saying this, Malad, I'm raising tribal issues here. Now, exactly these
So
things.
as per your submission, the document which they have disclosed in the affidavit in reply, that has to be dealt with properly, and that is a matter of trial.
Matter of trial, and these are new facts,
correct,
which were not there.
That's right.
That is a matter of trial, of course. And then, my lord, finally, I'll just show one more example. Page 35. It keeps changing, the loans and advances, when these are being paid back. So obviously, if the loan is being paid back, there'll be some transactions from account A to account B, if at all. Page 35 only, you also will see sundry debtors, High-Tech Air Systems and Mayo, which is the company. These two companies are those of the plaintiff. Plaintiff is a director in one, is a partner in the other. 97,000, 67,000 is owed to the deceased in 2023. So just by example, I'm showing that these documents have been disclosed by them. There are transactions both ways. It's a continuous account. Now, my lord will come to the petition to see how they have explained this, the whole situation. They have, my lord comes, and this is reflected also in my lord's order. I'll come to that order after. So I'll start from paragraph 1. If my lord will permit me to just run through the petition, I won't take very long, as far as the petition is concerned, my lord. In paragraph 1, he said.
So you are appearing for 1 and 2?
1, 2, 3. The widow, the daughter, and there's a HUF. So there appears to be a lot of transactions between the plaintiff and the deceased. And these have to be explained merely by showing two bank statements, or not even two bank statements, a statement by the bank that these monies went into my husband's account. It's true, it's gone into his account. Now, they have to prove that it was unauthorized. And this word unauthorized has been used just merely by repeating it. Before I show the pleading, one more. Page 66 of the petition, if my lord come, because your lordship has set this chart out in your lordship's order. Yes. That this is their big discovery of fraud. This chart at page 66. Now, your lordship will see ICICI bank account of plaintiff, then an arrow, transferred to 8 crores, etc., transferred to deceased bank account. This is what they have to prove, that this is the fraud. What happens to the money after that is irrelevant. As far as making a prima facie case, they have shown once the money, if this money was authorized or not, is a matter for the plaintiff to prove. And that has to be proved, my lord. If it is fraud, it has to be proved beyond reasonable doubt, even in a civil case. And if it is breach of trust, etc., on the balance of probabilities. Now, the probabilities show that there were other transactions. Now, it could have been several other transactions. He could have earned this money by commission, etc. Whether it is reflected in my income tax or not, that is a completely prejudicial question, whether he has disclosed. Ironically, my lord, my husband's accounts were audited, as well as the plaintiff's accounts are audited, because they are above a certain limit. Under the Income Tax Act, they have to be audited by the same auditor. Now, we have called upon the plaintiff as well as the auditor, my lord, to produce these documents, which are referred to exactly page 25 and 30. Those, what is this loan, when was it taken, etc. We have called upon them to produce also their IT returns to show what were the commissions that were paid to the so-called broker, etc. And we have given them a letter. They have not responded. We will take our own course, my lord, as far as that is concerned. And in my note, and may I keep a copy of the letter on record, my lord? There's no response.
Copy of the letter was received yesterday.
Yes.
Today was the hearing. Yesterday the letter was received.
Very well. I won't finish today because I've got some decisions to give. If they want, I said, that's why I said I'll deal with this later. But these facts I've brought to my, whatever's in the letter, I've already brought to my lord's attention. It's for them. I don't want them to come and prove their case tomorrow. So it's okay. I put them on notice. I've showed that these documents were disclosed by them. So I've asked for better particulars, that these entries, what do you have to say? What does your accounts show? Because you have got, the advantage they have got is they've got my husband's laptop. So they have got all my accounts. I don't have that. And the auditor, this Swiker, it's a common auditor. Now, that is so this chart that I was coming to, my lord, he says that this is the fraud. Now, 8 crores 95 has come into his account. Though these accounts have not been proved in the sense in a suit, they'll have to get Bankers Book Evidence Act, etc. They'll have to prove the authenticity of these transactions. But from the prima facie, yes, money has come into my husband's account. I'm not denying that. Now, what was it, unauthorized or was it authorized? Now, how can my lords sitting there on the basis of this evidence say which was what? Because there are some authorized, he has paid off his loan of 40 lakhs, he has paid off his loan of 25 lakhs.
So if we take the otherwise, if it is, though it is on record and it is to be decided whether it is authorized or unauthorized, so whether the amount cannot be kept as preserved, the amount cannot be preserved.
No, the object of making this argument, this is my first point that I was making, is these points were suppressed. Now, if your lordship knew that there's ongoing transactions, it's a question of accounts. It will come into at the late stage. These were not brought forward. So at this stage, they are not entitled. If they have suppressed material facts, or then they are not entitled to any order. Now, there are some other legal points as well, Manoj, I'll say. So as far as the chart is concerned, since it's set out in my lord's order, I want to explain this. Step 1 is not explained. Now, after that, they say that 5 crores went into this account and he has spent it in this sort of way. Now, the idea of this chart is that if there's a breach of trust, then the trustees can trace the money. Normally, your lordship, if I sue A sues B for money and B has given that money to C, it's irrelevant. I have to ask for sell B's assets. I can't chase C. If it's a normal, but if it's a trust property, then it can be traced into the immovable property that's bought, etc. So for that purpose, probably this chart is there. But this doesn't prove the fraud. And the pleadings they have made that defendant number 1 has unauthorizedly made all these payments.
That is the case they have made out.
Once it cannot be unauthorized from my account if I buy something, if I buy jewelry or flats.
No, that's it. Because they have case made out. This is the first one. It's 895 and 8 crore 95 lakh.
They have to first show that the deceased was not entitled to this money. This is the first step, which I'm saying that they have not shown. My submission is that prima facie, they have not shown that this is unauthorized. On the contrary, I'm showing my lord documents that these transactions is intermingled also with there must be authorized transactions as well.
Yes.
So this is on and those other transactions that were between the parties has been suppressed. So first point is of suppression. If I can show that they are suppressed, then they are not entitled to any relief at this stage. Number 2 is the acquiescence or the delay for 4 years. This is something that my lord has to consider while if passing an interim order or not. For 4 years, he knew his bank statement is there. If it was such a big fraud and this person was an accountant, he would know that the electronic record will show that the account is going from A to B. There's nothing hidden. It's his bank account. It's a statement. It could have been taken in fraud. It could have been to some relatives. They would have sent the money showing there's some transaction. Usually fraud is like that. But he will not be so blatant that he is transferring money from A to his own account. And he's the one who's giving the accounts no, and he's saying he helped him do the income tax. And auditor, both the parties' auditor is the same. I'll show that. So the second point is that a litigant, my lord, who is not vigilant, is not entitled to an ad interim order or an interim order. For 4 years, he is signing his income tax returns, I'm presuming. He has not produced those income tax returns. He has got access to his bank account statement from 21, 22, 23, 24, 4 years. 8 crores is siphoned. However rich you might be, but you will notice that there's this transaction from A to B, and this gentleman, the deceased, you know, should have to take that into consideration that maybe because of litigation, we know too much about fraud. So why will someone who's committing fraud not even disguise that this it's going from account A to B? He knows he's going to get caught if it is unauthorized. It's his master's account, so if you have to believe them. And there is no proof that he did it. It could have been done on the instructions of the plaintiff also. So each entry will have to be proved by them. When they do the cross-examination or whoever witness they bring, he'll have to say that this transaction couldn't have been mine. I never owed him any money as on that date, etc. But each entry has to be proved in that sense. So my first is suppression, no relief. Second point, I'll cite cases on these. I'm just giving my lord the propositions. Second point is if a non-vigilant or non-diligent litigant is not entitled to an interim order. On the face of it, he could have known this because he has access to all the accounts. Yes. It's not that like the pleading is there, he disguised and concealed it. How someone can conceal a statement in the bank statement is showing this is going to account number so and so, and they can find out. So that's the second point. Third point is, as far as fraud is concerned, the burden of proof is much higher. I'll show that. In fact, it's beyond reasonable doubt as far as this is concerned. So they have a large onus. Normally, you would have said from my account, he's taken it. Now, a practical example of this is, my lord, nowadays a lot of cyber fraud happens. But if you have voluntarily given the OTP, the bank is not refunding your money. That's the first step that you have taken part in. And here, now I'll place the pleadings. He has given me the deceased the entire right to run this.
That is that case there.
That is the case. So if he is authorized to transact in a bank account, the use of the bank account to transfer money from one account to another is not illegal because he's authorized. He hasn't forged anyone's signature, stolen an OTP, etc. He was authorized to do that. Now they are saying this transaction you are not entitled to, you have to give it back to me. That they have to prove. But putting this, if he has given this person a loan, he's entitled to get it back. But that's not their case. Their case is for no reason, these monies have been transferred. So that's the third legal point. Then when they obtain the interim order, they got a blanket interim order even on the insurance policies. Now I showed my lord the provision section 60 KB. I'll show the judgments. My learned friend cited one judgment which explains the nature of the money that we receive under a insurance. Well, that says that it belongs to the estate. So if the person still remains alive and the policy expires, if the money comes in, it becomes his money. And when he dies, it doesn't become the money of the nominee. He is only entitled to collect the money. It becomes a part of his estate, and who are entitled to it? His heirs. But in our case, the nominee and the heir are more or less the same. There's a minor daughter also, but the nominee was the wife. Now, as far as section 60 is concerned, on the face of it, no injunction can be granted if it is payable. Now, there are two sets of insurance. The LIC insurances we have not received yet. So that injunction, I will be praying straight away. Your Lordship lifts that injunction. Let the money come in. Then your Lordship decides if it's required for security or not, even after all these submissions. Then, so about 4 crores has 4.5 crores has come in from the private insurance, the life insurance parties. And about 4 crores, 399 or 3 crores 99 is due. So that money should come in. There shouldn't be an embargo because LIC will then sit on that money. That is one part of it. The second part is that if this money has come in and it is now in the account of the defendant number 1, then, my lord, does it lose its character as an insurance money? So the judgments I'll show, my lord, that it does not lose its character and still it cannot be attached, because this is a question of public policy, that the heirs are protected by this. I'll show the decisions, the reasoning why this section 60 is there. It is a question of public policy which overrides even the provisions of the Insurance Act that my learned friend showed. So that would be my, I'm losing count, my 4th or 5th point. That's the point. So on this basis, my lord, I'll take my lord through the petition just to remind my lord what they have pleaded and what they have not, and then I'll cite the cases. If my lord comes to paragraph 1 of the petition. So what is their case? Their case is that the deceased was a employee of a partnership firm. At all material times, the petitioner carried on and still carries on business in partnership with one Vishal Kapoor. He is not a party. Under the name and style of high-tech air systems, inter alia for sale, installation, etc. of air conditioners. So neither is the firm nor is the other partner a party. Yes. And as far as we have been able to ascertain, my lord, it's a company. It's a company. Your lordship will see the email ID is the husband's email ID, Kirti, High-Tech Air Systems Limited. And if my lord turns over the page, the plaintiff is a director, and this Vishal Kapoor and Mamta Kapoor are also directors. So it might be, I'm not disputing this, I'm just saying that it's for them to say. If it is, there might be both a partnership and it's always possible there can be a company also, there can be a partnership also. It can be, but it's just a coincidence. Be that as it may, paragraph 2. At all material times since 2009, Kirti, son of Rajendra Lunia, was employed in HAS as accounts manager. So he is not the employee of the plaintiff, in the sense that the bank account which they are alleging that has been defrauded is the private account, personal account of the plaintiff. It is not the account of the partnership. So he is an employee, according to the plaintiff, of the firm, or if it's a company, of the company. He passed away in June, that's right. Then, my lord, we'll see the allegation is in the middle of paragraph 3, the second sentence. The respondent number 1 was directly or indirectly involved in the perpetration of fraud and breach of trust along with the deceased in the manner stated hereinafter. So this is their allegation. Now, what is the fraud and what is the what is the breach of trust? They have to establish in the subsequent paragraphs. Now, then they've explained why the banks have been made parties. Though the statement, Your Lordship, paragraph 5, I'm just making a comment on this, nothing turns on this. All the said accounts were involved in the fraud. The accounts are never involved. Either the persons are involved in the fraud, the accounts are not. But they have made the bankers the parties. I have nothing to say. They have also not, I don't know, they are not appearing. And their allegation, the 4th line on the next page, is that these bank accounts, which are my bank accounts and his, were operated fraudulently. Now, this is in direct, and this is again repeated, operated fraudulently in paragraph 6. Now, this is in contradiction to paragraph 9. Your Lordship will note that I'm coming to paragraph 9. Then they talk about the other bank accounts, insurances. As far as the insurance is concerned, one point that's made here, I know it was also argued, that some of the premiums, they say, is paid with this tainted money. But that doesn't make, my lord, them beneficiaries to that insurance. That's neither here nor there. There might be an explanation. But that does not mean that they become entitled to ask the insurance company to pay them. I can pay the premium for a friend of mine, but I'm not the beneficiary or the nominee of that insurance.
All policies for the alleged period of
Yes. Now, Your Lordship had asked me this on the last occasion, that when were these policies made? All these policies were prior to 2020. I've got the chart. In fact, the latest one was one of these documents are there. Just for clarity, I'm showing this to you. The chart is the same as what my learned friends have also given, but it's got more detail. But just to show when did this commence, the fourth column, Your Lordship will see date of commencement. Their allegation is from April 2021. The 8x95 they've claimed is from April 2021. Right. So all these policies were there before. So they are saying some 27 lakhs worth of insurance payments before his death were made, and they are saying that was made from our money. No, it won't be reflected here. This is the date of commencement. This is the amount I'm going to get, ultimately 9 crores, out of which 4.5 has come, amounts received, and this 3 crores 59 lakhs. Well, this is the LIC ones. They are still payable, but we have not received. Now 4.5 has come. And this is lying in the account. It's been injuncted. There was which is the 24 lakh one? Of my point. This is not here. That's in the appeal court. But there was another insurance policy in the name of Rakhi, which in the appeal court we had shown that policy. But of course, the appeal court has not referred to it. But that amount is taken. 24 lakhs I was allowed to withdraw for my expenses. So that I have done.
So this details, this is prior to that.
Yes, this is all these, the policies were made prior.
Correct.
Really nothing depends on that. And they are saying that after that, a lot of the insurance policies were paid out of the money. So, but that doesn't show, whichever way it is, it doesn't show that they are beneficiaries, or it doesn't circumvent Section 60 at all. That is my submission mainly. So, Manoj, so the payment of the premiums does not give them any extra, right? 27 lakhs for all these, about 13 insurances. And this, admittedly, from my balance sheet, I could have paid those monies anyway, in any event, over the years. It's not that I was dependent on this alleged siphoning of the funds. Paragraph 9, if my lord comes. I'll go back to the case law just. This is the case. In the course of the employment of the said deceased with HAS, the deceased also earned the confidence and trust of the plaintiff to the extent that the plaintiff relied on the deceased for looking after the personal finances of the petitioner. Now, there is no contract that they have referred to. What are the terms of the contract? Was he to get paid at all? Or it was just, and he earned the confidence. It's not that he tricked him into the confidence, etc. That he is saying that according to the plaintiff, that he earned my confidence and I let him look after my personal finances. Was it for free? That's the question. The said deceased was also involved in the preparation and finalization of the personal accounts of the petitioner. But these accounts must have been audited. If it's in crores, he's earning in crores, he doesn't even notice that 8 crores has gone out of his account. And the submission of income tax returns of the petitioner. The confidence and trust reposed by the petitioner on the deceased was to such extent that the petitioner authorized the deceased to have access to the personal bank accounts. I'll show a judgment, my lord, that if you allow someone to operate your bank account, to sit on your property, then start building, then after a period of time, you cannot come and say, who are you to do so? This authority, and especially now after he's died, so it's an admitted case now I have abused, whether he has abused this authority or not, he has to prove. That is the thing. So prima facie, like your lordship said, that can it go both ways? If he is authorized, then my lord will take the view that yes, you are allowed it. You have brought it upon yourself. You trusted this person. He has authorized. He has not done something that's forgery or fraudulent vis-a-vis the bank is concerned. He was the authorized signatory. He could have done it. There's nothing fraudulent about his act. Now the whole thing is, did you owe him this money or not? And that has to be proved. That was it
The
commissioned?
authorization which has been given by the plaintiff to him, whether that authorization has been utilized by way of the legal way or
yes,
for his own benefit.
Then the plaintiff has to plead that I authorized him to operate the account only as per my instructions, only to do X, Y, Z to pay. So it can't be that if you've authorized him, and then, just to give an example, admittedly the plaintiff took a loan from the defendant. When it was paid back, if it was paid back from this account, who would operate the account? And this is only his statement. Like, you can authorize someone, but he will not do it unless the plaintiff tells him. So these, their case is that the plaintiff didn't know. He was disguised. For 4 years, is it believable, my lord? That crores of rupees have going, and on the face of the record, it's not that he has taken out cash and tried to explain it or disguise it in any way. So that prima facie case at this stage would be wholly in favor of the defendant because of this statement that the petitioner authorized the deceased to have access. Then, again in the paragraph, in page 9A, again it says that he had given him the mobile number, email, everything was registered in the deceased name.
Yes.
Admitted by them, at least. So this was completely voluntary. So the entire thing will depend on the proof that was these transactions which are alleged, the 8 crores 95, unauthorized in that sense. And what is the evidence before my lord that it was? Because this covers, at least if the entire accounts were not, it is the duty of the litigant, my lord, and especially a plaintiff, to disclose all the documents. What is material and what is not is to be decided by the court. But if they have their bank account and they say they pick and choose, your lordship will see the letter they've relied on by the bank. These transactions were sent to Kirti Lunia's account. What happened to the other transaction? What was the nature of it? What was the extent of it? Nothing is explained. So that is... Then, and the deceased is not there, my lord, to counter. They will have to come and give the evidence on the basis of records only. And I am submitting that there are no records to show that these were done in an unauthorized manner, especially since you have authorized him. Now, then, my lord, will come to page 12 of the petition. This is the money they are claiming has been siphoned off. And the money can only be siphoned off from the plaintiff's account. What I do with the rest of annexure M, the flow chart, that is not unauthorized. That is his attempt to trace where the money has gone. But Kirti Lunia was perfectly authorized to spend whatever money was in his account. Now, this page 12 is the money they are saying has been taken in an unauthorized manner.
Yes. 21
yes. So 21 lakhs, 1.8 crores, 2.6 crores, 3 crores, and they mean to say that he is not aware of this. He has not disclosed this. We have asked them in this letter to disclose their income tax returns also and their accounts. So all this money, my lord, has been taken. Every year he's signing it. So there is no complaint made. I've shown counter documents. My lord, in this period, 2021, 2020, 2021, 21, 22, all these periods, I've shown those 3 balance sheets. 2 have shown, page 25, 35, and 30 of the reply. So there were transactions, interstate transactions. At that time, he never said anything. Now he's saying that these amounts we have found are wrong. Then they have purchased some immovable property, though it's outside the jurisdiction, my lord, your lordship has injuncted them. So that property, according to them, is worth... Where did you get it? Reply. More than 4 crores. Now they have got this, the 4.5 crores is already there in the account. They have got that. That's 8.5 crores. Now they have stopped this 4 crores from 3 crores 59 lakhs from coming from the LIC. That I would be praying at least that be allowed immediately, even if I won't finish today. I will cite a judgment on these 5 properties.
Which one? Which property you're telling?
As for property, the properties are at the annexure N and P. Page 69 is one property. No, it's in the petition. Page 67. The injunction has been given here.
Acha, scheduled property. Okay.
Scheduled immovable property purchased. This is in Tullygunge. One flat number A, 1,200 square feet.
Yes.
And page 69, there's another flat and a shop room. So 3 properties. And according to them, it's over 4 crores. It's 588. I'm just giving a ballpark figure. That there's the property is there. The bank accounts have been, and this, and so this ad interim order, my lord. Also in the last argument that I will make is on a humanitarian basis, the entire thing cannot be stopped and they have to be given an opportunity. Now my main argument is this 4.5 crores cannot be touched under section 60. I want to cite a few decisions on this. I will also deal with my learned friend's decision. As far as yeah. Well, give me 1 minute. I'll just give the citations. Where's my bunch of cases? Yeah, this one. I have to get an iPad. I was enjoying this phase between the iPad and I stopped taking the brief also and stopped taking. This is most peaceful. Either. Well, if my lord sees first, I'll just start from first principles. 1984, 1 SCC, page 424. This is the mother case, which says what is the nature of the nominee. I'll just place the head note in this. This is referred to in all the others. But the head note is worth placing. It's paragraph 5, 8, and 12 is summarized. A mere nomination under section 39 of the Act does not give the effect of conferring on the nominee any beneficial interest in the amount payable under the life insurance policy on the death of the assured. That's fine. The nomination only indicates the hand which is authorized to receive the amount, on payment of which the insurer gets a valid discharge of its liability under the policy. Under section 39, the policyholder continues to hold interest in the policy during his lifetime and the nominee acquires no sort of interest in the policy during the lifetime of the policyholder. Therefore, on the death of the policyholder, the amount payable under the policy becomes part of his estate, which is governed by the law of succession applicable to him. So this is the thing. Then such succession may be testamentary or intestate. Section 39 does not operate as a third kind of succession, which can be styled as statutory testament. A nominee cannot be treated as being equivalent to an heir or legatee. The amount received under the policy can be claimed by the heirs of the assured in accordance with the law of succession. So in our case, nominee is the wife, but the heirs are the wife and the dependent 1 and 2. So now this money is deemed to be a part of the estate. This is what my learned friend submitted. It's given a case which is established on law. Now, can a creditor get his hands on this money? On this money, when it is, so section 60 of the, section 60, subsection 1. I cited that one. It's one line. I'll just read it out. It will be there in all the judgments as well. So the following particulars shall not be liable for attachment or sale. That is, all monies payable under a policy of insurance on the life of the judgment debtor.
Correct.
So if I assume that the deceased is the judgment, is going to end up being the judgment debtor in this suit, then, my lord, the policy on his life, that cannot be attached. Now, why it cannot be attached is very well explained in several judgments, my lord. I'll start, my lord, with Andhra Pradesh judgment. This Bomi Nayani Nirmala. My lord, 2010 SCC Online, Andhra Pradesh 216. It is very simply stated here. There are umpteen judgments, but I just want to start with this one. 2009 1. The question of importance with reference to the proviso KB under subsection 1 of section 60 of the CPC falls for consideration in this civil revision petition. The judgment debtors whose application for exempting the LIC claim amount of their predecessor was rejected by the court of the additional junior judge. For the sake of convenience, they are referred to as DH, the decree holder and judgment debtor. Then, my lord, the one Lakshmu Naidu had borrowed certain amounts from the decree holder. He had taken a policy of life insurance from LIC, etc. Then the decree holder filed the suit for recovery of a sum of rupees 81,000 against the wife and minor child. So here also the suit has been filed against them. During the pendency of the suit, the decree holder attached the LIC policy of Lakshmu Naidu. The suit was decreed in 2007. The decree holder filed an execution proceedings for recovery of the LIC amount attached earlier. Judgment debtors filed counter opposing the execution by attachment of insurance amount. Court below rejected the objections, allowed the execution, and directed it to be sent for garnish, etc. Then, being aggrieved, they went for civil revision. After receiving notice, decree holder appeared and the council made respective submissions. On a plain reading of KB of section 60, the money payable under a policy of insurance of life of judgment debtors will not be liable for attachment or execution of a decree. In this case, the policy of Lakshmi, predecessor of the judgment debtors, who himself is not the defendant in the money suit. Hence, the question is, when a suit for recovery of money due from the policyholder is filed against the legal representatives of the policyholder, can they seek exemption from attachment or sale? This is my case as well. My case is higher because there's no decree. There, even if you have a decree, you can't do it. Now it's a prima facie interim stage. The answer must be negative. Had the policyholder been alive, certainly the money payable on the such policy is unattachable. Even if a suit for recovery of the amount due from the policyholder after his death, the effect of the proviso is not taken away. This view has been supported by decisions of High Courts of Bombay, Madras and this court. Then this decision also I wanted to rely on. It's referred here. Federal Bank, that is AIR 1986, Bombay 2001. I will give it separately, but it was held. The reason behind this submission is that according to the Learned Counsel, once the assured died, the monies payable under the policy come to his estate. And therefore, his heirs and legal representatives are appropriating the said monies. And as such, the monies are entirely under the scope of, outside the scope of KB. I am afraid that this reasoning of Learned Counsel cannot be accepted, because they said that once it comes into the account, it merges with the rest. It cannot be accepted. I say so because, first of all, one has to bear in mind that the policy of the legislature that caused exemption to be laid down. I am of the opinion, and I believe, that the legislator had exempted from attachment the monies payable under the policy of insurance on the life of the judgment debtor in order to give some security to the heirs and legal representatives of the deceased.
Yes.
So there is a higher calling, as it were, that they have to be protected. This being the position, even though the monies are becoming part and parcel of the deceased estate, nevertheless, the exemption laid down under KB follows the same monies. I am fortified in this view by Supreme Court, that's Sarbati Devi's case, which I just cited, to the effect that the exemption was specifically laid down because the amounts payable under the insurance policy on the life of a person are otherwise attachable. In other words, Supreme Court pointed out that had it not been for the specific provision of Section 60 KB, the monies paid under the insurance policy of a life of a person would be liable to attachment and sale for satisfaction of a decree, because it will be a part of the estate, normal. I am thus of the firm view that that the monies payable under the insurance policy on the life of the judgment debtor are entirely exempted from attachment and sale by virtue of Section 60, irrespective of the circumstances as to whether the policy matures during the lifetime or becomes payable after the death. Then, my lord, Provident Fund, other cases are discussed. I'm not going into that. These are also Section 60 incidents, but they're not on policy. Then paragraph 8 and 9. In Pulugu Karnakar Reddy, this court reviewed the case law and held that the amounts payable under the insurance policy on life of the deceased are exempt from attachment for any dues insured under Section 60. Therefore, if the suit filed against the petitioners as successors of policyholder, the policy amount is exempted. The fact that attachment before judgment became final does not change the situation, nor the order that the court attaching the LIC amount operates as res judicata. So this is on, it was a simpler judgment, so I cited it. Well, there are, I think, 3 or 4 other judgments I want to say. My lord will make it part heard, because
yes, my lord. Now
we have just got some notification.
we are
This
we
is
are
not a
aware now
commercial
of
matter.
the notification.
And if your lordship doesn't write PTHD, then your lordship doesn't keep it, even after hearing us. Any day, my lord.
The lordship will also extend the interim order, which is still today.
Recording. Senses and suffering for the plaintiff. Senses and suffering for the defendant of 1, 2, and 3. Counsel for the defendant has argued at length in connection with GA number 1 of 2024, but due to paucity of time, hearing could not be completed. Counsel for the plaintiff submitted the interim order granted earlier is going to be expired today and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier is extended till this is a non-commercial, na?
Yes.
Non-commercial. अच्छा हमारा तो भी commercial नहीं है, non-commercial नहीं रहेगा तो पार्ट रहेगा ना, बहुत है.
I understand lordship now will be exclusively commercial.
Also, I think company.
But company is very little left. Though
There is nothing left of the company
that
jurisdiction.
was the mainstay of the junior.
It was one of the premier thing, but
Gone.
now IBC has changed the complexion.
Let the matter appear on. It is extended till 24th April 2025. Release the matter on 23rd April.
My lord, not fixing a time.
Now I think the time will
come on the 23rd.
As parted.
Lordship will mark it part.
As parted.
That's all right. Lord, on 23rd, my leader, Mr. Mukherjee, will not be there, but if Mr. Ghosh finishes, my lord,
yes, he has to finish first.
Testamentary matters.
Your Lordship, we are being led by Mr. Suman Kumar Datto,
Ah.
who is not feeling well and is under the weather. He's not come to court today at all, Your Lordship. If Your Lordship fixes two
What is
dates,
the matter about?
this is Kiran Baladevi, Your Lordship.
Kiran Baladevi.
Yes, Your Lordship. We are in rebuttal now, rebuttal stage, and for final arguments, Your Lordship, my instructions are that two dates may be fixed for completing the arguments on our behalf. In reply to them,
No, I don't
consecutive 2 days dates, Your Lordship.
I don't know from Monday onwards what will be the situation. That is to be seen because after this.
Assigned matter, Your
Assigned
Lordship.
matter.
Assigned matter.
Wednesday, Thursday. This Wednesday.
Your Lordship, if consecutive 2 days dates are given so that
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant, counsel for the plaintiff. Prays for time. Accordingly, case is adjourned. Let the matter appear on 16th and 17th April.
16th and 17th of April. Much obliged, Your Lordship. 16th and 17th of April. Time. Who is 12, 13, 12, 27.
I am appearing on behalf of the executor, Your Lordship.
Yes.
This has come up at the instance of the administrator. She wants a discharge. Your Lordship remembers that the learned administrator had filed all the accounts. We have no objection to that.
What is the GA3? Who has filed GA3? You?
GA3.
Huh?
GA6. GA3. No. Okay. Because of the administrator. Yes.
Yes.
It should do. Your Lordship on the last
occasion.
Your Lordship on the last occasion had directed the department to submit a report. It has been knowing applications are administrated.
I withdraw that. I withdraw that.
Which one?
I will have to now because I'm no longer.
For your application for repair work.
Yes, I will have to.
Take it.
Because if I'm not there, we will proceed.
Naturally. It has been administrator appointment for application terms. Wait. Appointment order.
When you have been appointed as administrator?
20th of April, 2015 by an order dated 20th.
So you have submitted the report?
Lordship, I filed my account.
Filed the account. ये assistant registrar कौन है? Call. Let's pass over.
Lordship, one more thing. I have one application is pending, which I have made. I want to withdraw that application as well. That
Okay, let the complete. Yes, next. आएगा बुलाना.
I appeal for the plaintiff. May I file the suggested issues?
Who is for the defendant?
My lord, I appear. My lord, they were supposed to file their judge's brief also. Are they filing it today? Are you filing it today?
We will make it ready in the meantime.
Huh?
Judge's brief, my lord, is not ready, my lord. It would be made ready, my lord, in the meantime, my lord. We are filing the suggested issues.
Have you have you?
Yes, my lord. We have already filed it on the last occasion. Your lordship will look into your lordship's order dated 7th March.
Yes.
My lord, we have filed. আমাদের একটা কপি দাও আমাদের অন্য আমাদের সিরিজের কপি আছে তোমার কাছে
So your defendant's issue number 1
Yes,
is
Lord.
covered under the issue number 2, whether the codicil dated Mobile person Jaran containing signature Sambuja and Asumcha. No.
Are legal and valid documents. Yes. Yes.
And that is covered. And execution or registration of the will dated surrounded by suspicious. That is 1.
That is 1 is a valid document.
Correct. So 1 and 2 is covered 1, 1, 2 of the plaintiff. Correct. Whether the petition of the affidavit of assets of someone that will taken into consideration. Whether the deceased had any beneficial interest in the bequest made by him. So that is covered in the testamentary capacity. Whether
No, my lord, that is not covered by.
that is not covered.
That is not covered.
Whether the will dated executed by deceased of free will and consent. That is covered under this 4. Or I will take the 5. You are 5. And
I
4 I will not take.
My lord, the beneficial interest.
No. 5 with will whether the you are 5. Whether the will dated 30th September was executed by the deceased out of his own free will.
Well, that will be covered by whether it is a valid one or not.
That's why.
Right. That's all right. My lord, the 4th one, my lord, whether the deceased had any beneficial interest.
That I am keeping. And your 4 is I am not taking.
Well,
whether the document purported to be codicil dated is manufactured and that is covered in the first
my
and
lord,
second.
this is my lord. My lord, this is a relevant issue, my lord, because we are challenging this codicil. Because this codicil, my lord, the defendant has produced.
My lord, that will
There
cover,
are
I
two
think.
codicils, my lord, of 30th December 2008. One
Correct.
is
Whether the codicil data kindly come to the issue number 2.
Yes, it will
Whether
be
the
covered.
codicil data 30th December and the 30 executed marble containing the
Legal and
signature.
my lord, that is our codicils. The codicils that we are producing. The defendant also has a codicil of the same date, another codicil of 30th December. There are 2 codicils, my lord, of 30th December.
You are not specify which codicil you wanted, either 4 or either 1 of the plaintiff or the defendant.
My lord, then it should be the codicil dated 30th December.
There are 2 codicils.
There are 2 codicils of 30th December of the same date, my lord. One the defendant is saying that the will has been revoked by the codicil of 30th December 2008, and the plaintiff is saying that the will has been modified by the codicil dated 30th.
Where is the affidavit of caveat? Affidavit in support of caveat? Which page in the codicil they have disclosed? In the affidavit of caveat?
But I am not carrying, the brief has not.
Which paragraph and which document?
My lord, it is at Annexure C, page 67, my lord.
67.
Yes, my lord.
Annexure C.
Yes, my lord.
Annexure C with the page 62. Codicil of my will date.
I bet 62, my lord. It's a printing. And my lord, it has been pleaded in paragraph 8 of the affidavit in support of caveat.
Paragraph 8.
Yes, my lord. They are saying, my lord, the will has been revoked by this codicil. And we are saying that there is another codicil of 30th December.
Where is your codicil? You disclose on the will?
Yes, my lord.
Is the disclose on the will?
Our codicil is executed by Shunmukh.
Your case is based upon will. Their case is based upon
the
the
will was
codicil.
modified by 2 subsequent codicils.
Where is that? You are not disclosed.
একবার বলো না যদি
No codicil.
It has been
You rely upon the will only.
affidavit on documents, ma'am.
Where is the will? Codicil only you are relying upon the will. Annexure B.
My lord. And thereafter, my lord.
Thereafter 2 affidavits.
My lord, in our affidavit of documents in the schedule, my lord, we have mentioned about the codicils, my lord.
How it can be? What is the case you made out in the probate application? Affidavit document, what the document? This is not the pleading. So,
my lord, at that time, my lord, there was a different advocate. So the probate application, my lord, they have not relied on the codicils.
no. And they have relied upon the codicil, Annexure C.
Yes, my lord.
That is also 30th September 2022. Your will is also 30th September, 30th December. September, both 30 September. What can be done?
My lord, these 2 codicils, my lord, are extremely relevant to our case. Because, my lord, the will has been modified by these two codicils and
Codicil, one codicil they relied upon in their affidavit in
yes,
the
my
court
lord,
of
by
caveat.
that they are saying that the will has been revoked.
Revoked.
And we are saying, my lord, that the will has been subsequently modified by these two,
there
but
is
that is not in the. I have just come.
No, that is not the case also. In the probate application, you have not made out such case. Can you come to your case?
My lord, I have seen that.
Nothing.
Registered will.
You're based on will. Nothing there.
My lord, after this application, my instructions are after this application, my lord, these were further disclosed by the.
It might be disclosed, but where is their amendment? Where is the case made out in the application?
My lord, then kindly grants me leave, my lord.
For what?
My lord, to produce these documents, my lord, because these are.
Production of document, whether you can go beyond the pleading. In the pleading, you have prayed for your probate in terms of the will. Okay, I am adjourning it. You think it.
My lord,
He cannot go beyond the will, my lord.
No, not going. I am not allowing. Only I am adjourning. As per the so-and-so appearing for the plaintiff, so-and-so appearing for the defendant, both the parties have filed the suggested issues. Let the same be kept with the report fixed on 9th April for framing of issues.
I'm grateful.
Password matter. Call the password. Have you gone through the order? Order passed by this court. Have you gone through this order? No, not this. Submitted the report. No. Gone through. What the court has asked for? Total report. Then where is the total report? See your letter. Where is the total report? What report? That's why I'm asking. Where is the report? I asked from 2015 to 2025 whether the administrator has filed the report or not. Where is that? You have given by pen. The registrar has given by pen. Okay. Complied with the order passed by the court. Huh? What misunderstanding? 2-line order. Not such and such. Report is that such and such report is with the court. You need not to submit here. The court has asked the report from 2015 to 2025. Total report means what? Read it accordingly. Nantam. Then where is that? Show me. If an earlier report is filed, show me where is the other earlier report. Your department is not conducting any accounts of any of the report. What procedure has been adopted? What the administrator will do? This he has to go. This is the way. If the administrator pending line or administrator appointed by this court is submitting the report, you are not maintaining any record, or the administrator pending line submitted the report and kept in the file. The judge is there sitting idle, he will check all the file. Then issue so cause. You persons are required only the so cause notice every day. What situation? Court has simply asked it to submit the total report submitted by the administrator. That's all. Missed. So where you are keeping the report? File is here. If they are submitting the report, where you are keeping? In your cupboard? So there is no report. That's why court has called for the report. Where is the report? Record an order. By an order dated 7th of March 2025, this court has directed the department to submit the report before this court, whether the total report has been filed by the administrator or not. But it is fine from the record, though the department has submitted the report, but the total but the query made by this court has not been placed before this court. Accordingly, the department is directed to show cause. The concerned officer of the department is directed to show cause why the order passed by this court dated 7th of March 2025 has not been complied with. Within a week from date, list the matter on 8th of April 2025. And the department is directed to comply the report and to submit the each and every report submitted by the administrator from the date of our appointment till date.
Lordship, I have filed my accounts. I have not filed any reports.
Whatever it may be, they have to give this. The court
Every
sitting
6
here don't
months I
know.
have been filing the accounts.
If you are filing the account, your account should be in that file. Yes.
Lord, I'm a petitioner, Lord.
My
application for amendment was being hard out. Now they have filed a supplementary
last
affidavit.
occasion, my lord has granted me leave to file a supplementary affidavit.
Rightly. They have filed it, they served a copy yesterday.
Okay.
Or Lord, I want to use a very short affidavit, but there is a
want to file
mishap in
reply?
my file, my family, client's family, my Lord.
Want to file reply?
Yes, yes. By 8th of April, Lord. Every Sraj ceremony, every completed by 5th of April.
So and so appearing for the plaintiff. So and so appearing for the defendants. Plaintiff has filed the supplementary affidavit. You are for the plaintiff.
Defendant.
I'm from the defendant.
I'm for the plaintiff.
Plaintiff is here only, but yes, the defendant has filed the supplementary affidavit after serving the copy to the learned counsel for the plaintiff. Let the same be cut with the record. Counsel for the plaintiff prays for extension of time to file reply to the supplementary.
But there was no direction filing reply.
Is there?
Oh, there was a direction. Sorry, I'll withdraw it. I'm sorry.
That's why I was confused.
I was not there the last occasion. I was not there the last occasion.
Wait for extension of time to file reply to the supplement. Let reply to the supplement and let the reply be filed within a week.
8th of April.
Within a week.
8th.
List the matter on 8th.
8th will I file it because their Sraj ceremony completed was 6th.
Filed by 8th April 2025. List the matter on 10th.
10th.
But can it be kept on 21 or 22nd or 23rd that week?
Then reply be filed by 11th. List the matter on 22nd.
22nd.
Deeply
Only
aware.
22nd, only 14.
Speaking.
My lord, I am appearing on behalf of the defendant, my lord. My lord, though there is no direction, I've candidly said that
Very small application for amendment, my lord, explaining the
We are-
delay in filing the probate
my lord,
application.
we are filing the opposition to the amendment application.
You are appearing for
Defendant, my lord.
what opposition? What application?
Very short amendment application explaining the delay.
Delay in?
Delay in filing the probate application.
We are
Lordship
raising the
is, my
point.
lord, is
My
quite
lord,
aware of the fact, my lord, the Supreme Court judgment which says that if there is,
there is
my
a
lord,
divergent judgment.
ground
Your lordship
taken, my
knows
lord.
Article 137 is also there, my lord.
What I propose,
Yes, sir.
subject to what he giving the explanation, what you are giving the reply. Let the same be come on record. That
Yes,
has
sir.
to,
My lord, I
and
finally.
this is the contested now.
Yes.
It is a testamentary that has to be proved
And
during the
another
evidence.
thing, my lord, my prayer is a change brief. My lord, that's why, my lord, we have not able to go through the documents, my lord. Let the time be extended to go through the documents also. And we have also not filed any, my lord, suggested issue also, my lord. Because
First, the inspection is to be completed.
yes.
So what about the amendment? What is your objection?
My lord, my objection is they have filed this probate application after 6 years from the date of death. My lord,
After
inspection
date of death of the testator.
6 years after the death.
Yes, my lord, Article 137. So for our contention is it is barred by Article 137 of the Limitation Act.
Barred by 137 of the Limitation Act. Article.
Article 137. 3 years.
My lord, application for probate, my lord, filed in 2022.
When died? When the date? What is the date of death?
My lord, the deceased died, my lord. কবে মারা গেছে? 10th February
2016.
2016.
That's why, my lord, I'm
6
writing
years.
by advocate on.
So that is, my lord, that is the reason why, my lord, I have come up with this explanation.
Yes, we have also given the, my lord, or I may file my opposition, my lord.
GA3? GA3?
GA3. GA3.
Our direction for
order
14A to 14D.
Yes. Only, my lord, to such extent.
Yes. Your opposition?
Yes.
Have you sub? Have you received?
No, no, my lord,
There was no
reply?
direction, my lord, for filing.
No reply. No direction.
No direction,
No
my lord.
direction. Because last time, my lord, they said that they do not have any instruction.
Counsel for the defendant prays for time. Your communication adjourned.
Yes.
There's no direction. Okay, whatever you file, it's other copy. You will file reply.
Lord, I am not very sure, my lord, what point. I believe my learned friend has taken the Article 137
That
point.
is-
I'll just deal with it's a point of law, basically.
So and so appearing for the plaintiff, so and so appearing for the defendant. The plaintiff has filed an application being GA3 of 2025 for amendment in the probate application. Counsel for the defendant has filed affidavit in opposition in connection with GA3. After serving the copy to the learned counsel for the plaintiff, let the same be kept with the record. Yeah, your GA number is to be corrected. 3 of 2025, it was not 24.
Correction.
Full list of the counsel for the plaintiff prays for time to file affidavit in reply. Let affidavit in reply be filed within a week. Within a week, list the matter on 9th April.
And my lord, your lordship has already directed me lord for completing the discovery and inspection,
Yes, sir.
which we have done because we had served it to the erstwhile advocate on record. He refused it. We have served
Now
it
we have
to my
entered
learned
into the-
friend's client
Completed?
directly.
No, my lord, so far our part here.
My lord, we have served the documents, my lord, directly to my learned friend's
Completed.
client.
What you are filing?
এটা দাও।
But now he has come. Can I pass a separate further direction? Have you inspected?
My lord, if your lordship kindly takes, my lord, the order dated 14th November 2024. চিঠিটা কোথায়? এইটা আছে চিঠিটা?
कुछ नहीं
তাহলে রেখে দাও।
Yes.
So
already there is a direction.
Yes, but that direction has not complied with article.
So what can be done? What document you are having? This is a will. Only the will is there. You are having any document?
No.
You are having any document? You light up any document?
Well, we want to see the will only.
Okay. I am extending this. So the council, though earlier this court has directed the parties to complete the discovery and inspection, but the learned counsel for the defendant submit that is a change brief and the intent to inspect the document of the plaintiff, and he will not rely upon any further document. Accordingly, the plaintiff is directed to disclose the document to the defendant within a week.
Yes.
Yes, we
Within
have
a week.
served it to my learned friend's client directly.
Within a week from date, full stop. The defendant on receipt of the said document shall inspect the document.
My lord,
within a week
for safety reasons, my lord, we
weeks.
shall again, my lord, serve to
That's
my
what I'm
learned
telling.
friend.
Within
Yes.
a
My
week.
advocate on record.
Within a week, and after receipt, then you complete the inspection within a week thereafter. So
Serve it within a week, because the
Yes,
executrix is, my lord,
Yes.
80 years old.
You have to disclose within a week, and after receipt, then he will complete the inspection within a week thereafter. So I am fixing within a week. आज कितना तारीख है? 24, नहीं 27 है. 8 है. 1, 2, 3. On 22nd.
22nd.
For framing of issues.
Right.
For hearing of GA3 and framing of issues.
And framing of
The parties are directed to come with the suggested issues and affidavit of documents.
Grateful.
I am for the plaintiff in the matter. This is appearing for the first time after conversion into the testamentary suit from the PLA. So the usual standard order may be passed for a discovery inspection.
Converted? Number
Yes, it is
assigned?
converted. Yes, number is also assigned. It's now TS number 6 of 2025.
So discovery and inspection is to be
That needs to be
record, ma'am. So and so appearing for the plaintiff, so and so appearing for the defendant. The parties are directed to complete the discovery and inspection of the document within 3 weeks.
within 4 weeks, ma'am.
4 weeks. Within 4 weeks, full stop. On completion of the discovery of the document, the parties are directed to file their affidavit of document within 2 weeks, 1 week thereafter. Full stop. In the meantime, the parties are also directed to to exchange the suggested issues. Full stop. List the matter. 4 weeks and 1 week. List the matter on 6th of May for framing of issues.
So far as the other matter is concerned, it's settled by our Honorable High Court only. In the division bench, a judgment was also passed that limitation does not apply so far as the will is concerned.
I also pass one judgment because there are contradictory judgments are there.
Delay in filing.
Yes.
Your Lordship, in item number 56, Mr. Oishik Chatterjee is appearing as a plaintiff. There's been a bereavement in the close proximity of the learned advocate. He has gone to attend final rites, Your Lordship. You are also the defendants in 57 and 58.
This is that matter.
There's not two applications, belatedly file applications. I am seeking only one relief, chance to file an affidavit in support of KV and the KV. That's very short point. But there is no point actually. As a plea, if Lordship decides it in my favor, I'll be filing it in time-bound manner, and there will be no delay in the proceeding.
That may be granted.
No, Your Lordship, I have something to add. I mean, 57. This delay is after 1.5 years with full knowledge. Now, if this is, they have not prayed for condonation in any ways. If this is granted, it will be, I don't know, perhaps setting a very bad precedent. So I have submissions to make, Your Lordship, and the prayer made by my learned friend, I cannot oppose that. He's gone for his last rites. Not that, the last rites prayer, Your
My
Lordship.
prayer is not objecting.
Yes.
Yes.
So far as my learned friends initially said, but
Let his senior come.
But he said that he has no problem if this prayer is allowed.
Let his senior come. He don't know.
I am ready to argue this point because delay will start from a date. That date is the date of I received the citation. In this matter, there is no citation. From which day I'll consider the delay. The point of delay is not there because there can't be a calculation of delay unless I receive the papers. I have my prayers are there for issue of citation and everything. There is no one from what there must be a date from where I will count the delay and will ask for condonation of that.
Okay.
The general pleadings are there.
So and so Supreme
We are
Court.
filing our affidavit, Your
The
Lordship.
referee in reply be kept in record.
Opposition.
ये cost title देखने ना कौन क्या खेल रहा है, हाँ? ये क्या?
हाँ.
You are appearing for
In
plaintiff
TS 25.
What you are filing?
Affidavit in opposition.
Counsel for the plaintiff in TS 5 of 2023 has filed affidavit in opposition with the same record with the record. Have you received?
Yes, I've given my reply. May I file my?
Full stop.
I've given
Let the matter appear on.
Kindly record the reply. I have filed the reply.
The plaintiff has also already. The defendant has also filed the reply. Full stop. This is the matter on 9th April.
Gratefully.
Lordship.
Wait.
Like this application had moved the last week, Malad. I was seeking for an interim injunction on the properties of the deceased in an application for appointment of a administrator pending detain. Malad, someone came on behalf of the defendant number 1 saying that we'll file within 2 days' time. Opposition, please do not pass any injunction. And your lordship was pleased to, that's why fix it today after opposition, after meetings when it's coming. Your lordship.
I file the opposition, it was filed within time.
How much opposition then?
I appear for the defendant number 2. I am
What do you want?
So far as the injunction on the estate of the testator, I filed an objection to the opposition filed by defendant 1.
Huh?
No opposition. Yes.
Then your lordship, I need to deal with it because it's served in the morning.
You do one thing.
It's served in the morning.
Take seat. I will hear both of them first.
Well, I'm okay, man. Till that time, kindly pass
No. The
Well, that's
affidavit,
what is fine.
the affidavit of asset is wrong.
Yes, all the reply.
They are fighting. So let them fight till that time, man. No. Let me do my matter first. What? No.
And your lordship, one indulgence, your lordship.
Yes.
Mr. Dutt is leading me in this matter. He is not well. He is little under the weather, and
Well, then
he has
let
requested.
them. I am not
No.
asking for an interim order in the space, Mallet. I'm only saying till the matter is taken up, let them don't do anything.
No, I don't
Because
have
there
any
is
instruction.
specific.
Because the asset list which has been described by
Come on Monday. Come on Monday.
But Monday mein part had Mallet.
No.
Mallet kind of orders Mallet Monday Mallet.
What?
But nothing will happen. It's after 2 years.
2 days, nothing will happen.
Determination change, Mallet.
I don't know.
Part had kind Mallet. Kindly Mallet.
I don't think Mr. Tharka is opposing.
I don't think. I don't think my determination is changed. Come on Monday.
Then I
don't know. I don't know because I have not seen my determination.
Monday is a holiday. Maybe come on Tuesday.
That's why I'm submitting Mallet. Let there be an interim order till.
No.
Mallet, because Mallet, what is happening, please?
Please.
In the opposition, Mallet, they clearly state.
Because automatically Mr. Dutt is also not there.
I understand, Mallet. The same reason I did not oppose the earlier day, Mallet. And on the ground that today we'll be moving for interim orders, Mallet, kindly appreciates in their opposition, they're specifically saying that certain properties of the testator, deceased, Mallet, are not his properties. And they are trying to deal with that. That is what I'm on.
No, we have disclosed the IT records. The IT
Mallet,
records itself shows that the
Mallet, IT records is not a disclosure of title, Mallet. I will show the memorandum which they have not objected
the income tax
to.
return of the
Mallet,
testator, he does not.
Are you ready to do the matter? Then let's do the matter. Let's not do it in piecemeal, Mallet.
So appearing for the plaintiff. So appearing for the defendant number 1. And so appearing for the defendant number 2. The defendant number 1 has filed affidavit in opposition in connection with GA3.
GA3.
GA3 after serving the copy to the learned counsel for the plaintiff as well as the counsel for the defendant number 2. Counsel for the defendant number 2 file objection or affidavit. Affidavit in opposition.
Affidavit to the opposition filed by the defendant number 1.
So may I have the leave to file a reply?
You got that this
It's only to be since they
Now he wants to file a reply, so that
Exception. I
That
have
is
not
out
asked
of
him
the
to
bag.
file an opposition.
That is out of the bag.
I'll reply to the affidavit in opposition filed by the defendant number 1. Let the same be kept with the record. List the matter. You want to file reply?
Reply. It has been
If
served
any
today
transaction
morning
was
at
subject
11
to the
o'clock.
result of-
For the plaintiff, counsel for the defendant number 1. Press for time to file rejoinder to the reply filed by the defendant number 2. Let the rejoinder be filed within 2 days. List the matter. Rejoinder be filed by
Tuesday, Your Lordship, because
by Tuesday. List the matter on 4th.
Well, may I just only request your lordship, my lord, an observation to the extent that if anything is dealt with, it will abide by the result of this application. Innocuous, my lord. Kindly, my lord. Or else, my lord, they are just going to deal with it, my lord.
no.
Come on, 4th.
My lord, may I make one submission? My lord, I had filed a prior application where my lord, the coordinate bench had already granted an order.
That is why, my lord. There's
No, no. Different property. 1 second. My lord, 1 minute. A different property was admittedly sought to be dealt with by this defendant number 1. Today, the apprehension is he will deal with further properties of the testator. This is a defendant who has not challenged the affidavit of assets filed in this probate proceeding.
That property does not belong to the defendant number 1 or any of it.
Kindly marks it as part of my lord.
You have
Why
challenged
no?
the assets.
My lord,
I
that's
am
not the
opposing-
intention.
I am opposing the injunction, not the part.
Then let it be part.
That is up to your lordship.
Hearing notice about the
My lord, let me start the hearing then, my lord. To the extent it will be parted, my lord.
Come. Yes, next.
Oh, winner. Oh, deal court is
Mr. Rai will try luck with a different court. 100%. 100%.
I have seen the roster, my lord. Therefore, my lord,
I
I
have
was.
seen the roster. Mr. Shorkan knows this.
No, I haven't seen
That's what he is taking advantage of. By knowing this.
All bar knows, but I don't know.
This is the hour back. It's only now 1 hour back.
Yes.
This is my application for amendment.
Lordship, I am for the respondent.
Now, there were some amendments in the. This is the matter, my lord. Amendment was allowed in.
You have filed sought for
No, Lordship will kindly see my lord's order at page 18, 1-8.
1-8.
Yes. Initially, there was an amendment allowed, but there was some defects. So, report from the department was called for, and on scrutiny, there are some defects which were indicated. The defects are in the proposed.
Yes.
So, I have filed the new application. The proposed amendment is at page 23.
Yes.
So, this 3A, 3B, where during the lifetime, one of the properties has been dealt with.
23.
23.
20.
Starts at 20. I think this is not paginated there. Yeah, yes, for me also I found.
Annexer X.
Yes.
So 3A, 3B.
Yes, 3A, 3B. Then, my lord.
Then 4.
This 4, the legal heirs names comes in. On the death, the legal heirs names comes in. Then the new address, the names were there.
I have to take objection to this. Lordship, the first prayer is leave
No,
be
you
granted.
want to file affidavit or
Yes, I want to file affidavit.
So suffering for the plaintiff. So suffering for the defendant. The plaintiff has filed an application being GA 7 of 2025, praying for amendment in the plaint/probate application. Counsel for the defendant prays for time to file affidavit in opposition. Let affidavit in opposition filed within 2 weeks. Reply, if any, that will be filed within a week thereafter. Release the matter on 10th April. No, 10th April. No, 22nd April.
23rd. 23rd. I'm great. We got an exclusive commercial determination. Good now.
Exclusive?
Exclusive commercial. Exclusive commercial from Tuesday.
I'm for the petitioner, my lord, I'm paying for.
Not this
And
way.
I'm appearing for the caveator.
I am
Please permit me to join from online.
I am appearing on behalf of the caveator, Your Lordship. Your Lordship, I am beseeching Your Lordship for expediting this suit because it's my residential home. They are residing over there by virtue of
You
a.
convert it to the commercial, then I will accept.
Then Your Lordship kindly
today.
posts it, kindly does it
Not
not
today.
today. Very well, Your Lordship.
As per the prayer made by the council for the parties, case is adjourned.
For the parties, kindly don't.
Only not today, please. Not today. Not today. Yes, Mr. Banerjee, how are you?
Long time.
After a long time.
Yes, after a long time. After we are fortunate,
Health
Lord,
is-
because all right, my Lord.
Health is good?
Yes. Lord, only formal order is to be passed because caveat is already lodged. Discovery, inspection, and judge's brief of documents.
Who is for the other side? You are for the plaintiff.
I am for the plaintiff.
Testamentary number दे दिया.
They file below defendants file
Caveat.
caveat.
Affidavit in support of caveat.
Caveat.
So and so approved for the plaintiff. For the caveat. For the
Discovery inspection. Yes, my Lord, my Lord.
Only one thing, my Lord, we came to know about the proceedings, my Lord, from the newspaper. Citation was not issued because in the probate petition, my Lord, they have given, my Lord, a separate address. So, my Lord, we could not, my Lord.
Who are you?
Lord, I appear for the caveator, my Lord.
You have not filed the affidavit in support of
Yes,
caveat?
I have filed. My Lord, only thing what I want to tell your Lordship, my Lord, the probate petition was not served upon us prior to our filing of the caveat. So, my Lord, what happened, my Lord? We have
No,
not yet with the.
caveat to file karo.
So, my Lord, what happened, my Lord? We will take out an application, my Lord, for additional written statement, my Lord, dealing with the averments, my Lord.
Where is the application?
My Lord, we will file. We will file.
You will file.
Yes, we will. It's ready, my Lord. We will file, my Lord, in a week, my Lord.
What is the GA2?
GA2 का किस है?
Their application.
GA2 का किस application? हाँ?
Treated as contagious, that is disposed of.
Yes, that is disposed of. Application.
Contagious cause.
Yes.
So,
I'm not copy.
We will take out an application.
Lord,
Your Lordship can pass.
copy was served on them.
do one thing. I am passing an order for discovery and inspection of the document.
Yes.
Correct. In the meantime, you take steps.
Yes.
No problem.
Yes.
So and so suffering for the plaintiff. So and so suffering for the defendant. Full stop. The parties are directed to complete the discovery and inspection of the document within 3 weeks. Full stop. On completion of the discovery and inspection, the parties are directed to file their affidavit document within a week thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues. Release the matter on 3 weeks, 1 week. Release the matter on 2nd May for framing of issues.
Lord, I am deeply obliged.
Thank you.
One kind leave to mention, from Tuesday I cannot wait. Your Lordship will not. Your Lordship, it is an ordinary division matter. If matter is going to be listed before the GA is going to be listed before Lordship on 26th. As the date has passed, we cannot file in the department the affidavit of service. Only
what affidavit of service?
Affidavit of service for the GA has already been served. For this, in the department, the notice of motion needs to be filed along with the affidavit of service.
In which PLA matter?
Not PLA. It's a ordinary. Suit matter.
Suit matter. You want to file a GA?
GA has already been filed, Your Lordship. It's with your Lordship's court. Your Lordship, that matter is going to be listed on 26th. The matter doesn't get listed. That's not a problem, Lordship. Now, the notice of motion needs to be filed with the department along with the affidavit of service. The affidavit of service is ready today as this it has been served by today itself. So, Your Lordship, small leave is required from Your Lordship to file this notice of motion.
Why leave is required for filing?
The department is asking for the leave, Your Lordship. The notice of they are not accepting.
It is non-commercial or non-commercial?
Non-commercial. That's why, Your Lordship, I cannot wait till till Tuesday. That's the problem. That's why.
When? Today? 4th. Come on 4th. So the other judge will be there. You mentioned before the other judge. No, no, no. How? The fourth is long way.
two sureties, my lord. My lord, petitioner is not in a position to pay, my lord, 7 lakhs.
7 crore rupees, 7 lakh you're not able to pay.
My lord, in a separate matter, my lord,
Actually, you persons are not pursuing. This is the order is, I should not say, that is not the proper procedure. You persons are not fighting with that. The surety is not required, but you are not pursuing that.
my lord, petitioner is the only legal heir.
So
my
what
lord.
can be done,
There's
sir?
Nobody, my lord.
So what you want?
My lord, my lord, I prayed for 1 lakh, my lord, in my prayer.
7 crore, 1 lakh.
Not 7 crore, my lord.
No, 7 crore, that's why 7 lakh has been given.
70 lakhs. My lord, out of 70 lakhs, my lord, 50 lakhs only, my lord, immovable property, he will automatically, my lord, inherit the property, my lord, since he has nobody, my lord. And only, my lord, liquid cash, my lord,
Mention
30
before the
lakhs.
regular court.
My lord, kindly, your lordship, my lord, today is the last day, my lord, kindly, my
Testamentary
lord,
time is over.
my lord, kindly, my lord, this is the order. My lord.
the morning. We are happy. Your lordship can have commercial could hold.
Exclusively commercial now.
We are all happy. We are all very happy.
Exclusively commercial.
My lord, kindly, my lord, kindly, my lord. I brought the order, my lord. And I
Pass, madam.
your lordship already, my lord, I pass an order, my lord.
So what you want now?
I'm praying for reduction of amount, my lord. My lord, kindly, my lord. He is not in a position to give, my lord, 7 lakhs, my lord. My lord, surety I can arrange, my lord, but 7 lakhs, my lord, this. I'm not in a position.
Surety, 7 lakh is deposited. They want the secret deposit.
Kindly reduce the amount, my lord. My lord, kindly, my lord.
They want.
It's the last day, my lord. I got
The amount is to be deposited.
No, my lord, the fixed deposit, my lord. This is my lord, kindly, my lord, kindly. Kindly, my lord. Today is the last day, my lord. My lord, I have various testaments.
She is making the submission, so I am going to retire.
I have so much testamentary matter, my lord. That is why, my lord. I'll kindly reduce the amount, my lord. Kindly, my lord. This is the order.
Yeah,
my
order
lord.
बताओ.
This is the order, my lord. Petitioner is the only legal heir. 7 lakhs. 7 lakhs নেই তো টাকা, অত টাকা নেই। Fixed deposit জমা করতে হয়।
FD.
FD, my lord. Kindly, my lord.
Counsel for the petitioner has mentioned the matter. By an order dated 25th of March 2025, this court has disposed of PLA number so by directing the department for issuance of letters of administration to the petitioner to the state of the credit of the deceased, subject to furnishing the personal bond of ₹7 lakh with 2 sureties. Counsel for the petition submitted. The petitioner is very poor and is not in a position to, and the petitioner is not in a position to arrange ₹7 lakh. And as such, the petitioner and as such, the counsel for the petition prays for reduce the surety amount. In view of the above, in view of the submission made by the counsel for the petitioner, the petitioner is directed to furnish personal bond of ₹3 lakhs with 2 sureties.
I'm so grateful, my lord.
2
I'm grateful,
sureties instead of 7 lakh with 2 sureties.
my lord. I'm grateful.
This order may be incorporated with the order dated 25th of March.
And again, my lord, I usually don't come and disturb my lords.
I'm grateful.
Item 6, today in lordship's commercial matter, the commercial matter was fixed at 3:45.
Today?
Yes, today. But today again there is spin of the ball. 3:30 is a course. Friday, difficult day. My lord, just praying, my lord. I need
Item number
6.
Item number 6 of commercial.
My other side is here.
Commercial,
Commercial.
Commercial, my lord.
So commercial will be here only. So
No,
what
I
you
thought
want?
that the matter was fixed because it was not being taken up in
You
view of
do
some
want-
heavy matters upstairs.
That's why, see, now my list will be, all the dates have been gone here and there. Come on Monday, it will be in the Monday's list. Come on Monday,
Maybe Monday, Tuesday.
Or Tuesday might be.
Loss, there is a.
Now there is every day this court has to take the commercial matter. You will get the chance. You want the fix.
Unless fixed, my lord, his senior, my lord, who is submitting?
Who is your
Problem
senior?
The Thakkar, my lord, senior. No, kindly fix on 2nd, my lord.
Second, I have difficulty, my lord. Second, except 2nd or 9th, any day. Till 10. That's why I don't want, I do not know what is the position of the diary after that. Going through the determination, then I have to fix my diaries because. But I am telling, I will let it be come on Wednesday or Tuesday or Wednesday. If it is come, if you have any difficulty, I will fix the date. No problem. That I can assure you. It will be in the list. It will be in the list. It will be in the list. Come on Tuesday or Wednesday, whatever it may be. If you have difficulties on that day, I will fix the date. No
Lordship, I'm mentioning one matter. The matter, the plaintiff has given 50,000 cost because the witness was waiting. But actually, the last order, there was no order for witness action. It was fixed for hearing. My juniors have wrongly submitted. Kindly just.
File an application. Yes. Call the list. Call the list.
I was cross-examining the defendant's witness.
Yes. Item number?
14.
Mr. Banerjee is appearing for defendant. He is coming.
Is assigned to this court.
Assigned?
Sigh of relief. The first question I asked her, the advocate on record, assigned. Chalo, let me start. Best, done. This is. We got 4 benches now. There's 4 bench now. 3 normal interlocutory, 1 commercial, 1 arbitration.
And
there are 4 benches.
Interlocutory at that IP also?
IP separate. Then 5.
5 benches.
Effective 5 interlocutory.
So your testamentary and other, the normal suit will go fast.
Yes, normal suit will go fast.
Because 3 benches are there now.
There's another, the transferred, we saw the notification yesterday. If it is done, then we'll get another judge.
But the total commercial is, I don't know.
Yeah, huge. We get an extra slot from 12:30. That extra slot will be there, 12:30 slot.
It is total.
Totally, yeah, much better. Roj. Now let me start. Cross Cross Mr. Bhattacharya, did you check up your inbox?
Yes, it is there.
For the email of
For
the email dated 11th May 2010.
It is there.
It is there. Did you also check up the no objection certificate, the provisional no objection certificate that was issued by the fire department?
Yeah, it is there.
Are you carrying a copy of that? No. Well, now this, she will kindly see the deposition once. There was because I was showing to the widow email 11th.
Which question?
90. It's starting from
90.
83 and 90.
9. Yeah, 9. 90. Yes.
90. So this email, I was carrying a printout.
Why did you reply the email?
So I don't want to ask any more questions. The witness has said that it is available in the inbox, because for me, I cannot even find out from my inbox. So this document can be marked. There's no 60 there because it's issued by my client. The email below.
So this is not the disclosed document?
It's not a disclosed document.
I informed them.
No. Yes. That has been done. That notice to produce given, and we have given notice to put, notice to admit also.
But my lord, it was in their custody also.
Correct.
But they did not disclose this at the time of it. So how they can produce this kind of, that can be produced as an evidence.
No, Rizal, I'm confronting.
My question, actually.
Is issued to them from my client, issued to him. I'm confronting the witness. That I can do in any proceeding, commercial, non-commercial. And the witness has said he has received it. I'm not asking any further question. It is in his inbox. Yes, I'm not asking any further question. This notice to produce, notice to admit given on January.
Okay.
In January.
Give.
I'll show it once again. Is this the email of 11th May 2010? The email in the below.
That's below.
Toilet.
Could be, sir. I have received a mail. I'll just check. I'll inform the court. It could be.
Could be.
Could be.
Could be.
Could not
It
be. Also.
could be. I received the mail.
I received a mail on this date.
I received
Contents I have not verified.
Contents
Not verified.
Contents why you will. I'm not. But now this can be marked as an exhibit. I'm not asking him for the contents. Why he will do. What exhibit?
What is the last exhibit? Huh?
14.
Exhibit 14.
আমাকে একটা কপি দিয়ে দিস এটা আমার কপি থ্যাংক ইউ না এটা তোর কপি আমারটা জজকে দিয়ে দিন ঠিক আছে তুমি রাখো কপি দিয়ে Mr. Thank you. Mr. Bhattacharya, I suggest to you that you acted in breach of the that you acted in breach of the development agreement. What do you have to say?
I don't accept.
I don't accept.
What
do you have to say? I disagree.
Disagree.
I further suggest to.
Just
sorry.
The earlier exhibit, na? That is not 18. It is your side. You are the plaintiff.
I'm the plaintiff.
Yeah, you
It must be ABCD.
H.
8. H.
Not
H.
18.
H.
It will be H.
H. হ্যাঁ ও H হয়ে গেছে না চেক করে নি কোনটা H1 বলো না এটা ভুল হলো ওটা তোমার H হ্যাঁ H কি I হবে চেক করছি আমরা দাঁড়াও
G1 না H হবে
দেখ তো বাবা কত কি হয়েছে
হ্যাঁ
আমি একটা প্রশ্ন করি
H/1 कौन सा है which document is H/1
H/1 is a schedule of the plat PD9 দেখো তো PD9 is H/1 H is PD8 the registered deed of conveyance
It should be I. Should be I.
I.
Last was H series.
यही थे फिर I कर दो I
मार्क করে রাখো
I yeah exhibit I
তো এক্ষুনি হয়ে যাবে
देखो फिर बताओ let just a minute
মাইল চিফে বলতে হবে আমাদের চিফে হবে হ্যাঁ এটা এক্সিবিট লিস্ট দে বাবা না
cross examination
H तो उसमें कर दो इसका वो डॉक्यूमेंट का है
पाচ্ছি না
देख लो नहीं हो तो करेक्शन कर दो हम नोट कर दे ऑर्डर कर दे
thank you
yes
I further suggest to you that you acted in excess or beyond the powers conferred upon you under the power of attorney.
How, sir?
So you can't question me. It's my
yes
suggestion.
or no
Whether you
is it
accept
correct or not
no
that's
Disagree.
or you want anything more than what you can make your some
okay
you precedent but you cannot put the question
okay,
to it.
You can make a voluntarist. I further suggest to you that you have illegally and without authority sold portions of the building in question.
I disagree.
I further suggest to you that the power of attorney executed in your favor never authorized you to sell any part or portion of the newly constructed building.
I disagree.
I further suggest to you that you acted in breach of the memorandum of meeting dated 28th of January 28th of January 2008.
Can it be presented, please? Can it be presented? Memorandum.
Can you show the show the
Okay,
document?
I'll show you. Exhibit 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 C.
C for Calcutta.
हमें तो खाने कम শুনছি নাকি আজকাল খেয়ে জানি Exhibit C
Show an Exhibit C.
page 51
Page 51 of the
judge's brief judge's brief দিলে judge হবে
Page 51.
page 51 judge হ্যাঁ মাইন্ড হবে page 51 exhibit এখানে এটা এক্সিবিট হচ্ছে তারিখ কত
I disagree.
I disagree. Yes. Next.
I further suggest to you that you acted in violation of the rules and regulations of the Kolkata Municipal Corporation.
I disagree.
I further suggest to you that you have not given possession of the owner's allocation area to the owners till date.
The owners are in possession of it now. I disagree.
I disagree. I further suggest to you that you could not have sold a portion of the first floor of the newly constructed premises in exclusion of the plaintiffs.
Reframe the question, please, sir.
Repeat, madam.
Repeat.
Here.
So,
Further suggest to you that not have sold a portion of the first floor of the newly constructed premises in exclusion of the plaintiff.
agreed.
I agree. Mr. Bhattacharya, you will agree that the second floor of the premises was sanctioned as residential.
Agreed.
Agreed. You will also agree that you sold a portion of the second floor for commercial use.
I have sold it. The usage is on the user and for the municipal authorities to see. The usage is on the user and for the relevant authorities to check whether it is being done rightly or not.
Is it your evidence that the document, the deed of conveyance, by which you sold a portion of the second floor, did not record about the nature of use?
It did. I would like to elaborate on this.
It did, bole, whatever he said.
Volunteers, huh?
It did.
Witness volunteers.
If something was in conflict with the law of the land, it's up to the law of the land to take it up. I had the right to sell, I sold. Law of the land. It is for the relevant authorities to check.
আর কি আমার কিছু কোশ্চেন নেই হলো Did you now I take it that no permission was taken by the concerned authorities, particularly Kolkata Municipal Corporation, when you sold a residential area of the building for commercial purpose?
For commercial or residential, no such permission is required. If something is used contrary to the nature of the sanction, then
it is required for the people, which is the municipality and the purchasers, to take the relevant sanctions or relevant permissions.
এটা দেখাও তো একবার page 94. So I take it that you admit that at the time of selling the second portion of the second floor of the premises, you were aware that the purchaser, now you permitted the purchaser to use the property for commercial use.
Sir, for the usage, I am not the authority to allow somebody to, in whichever way they will use. In whichever way they will
exhibit. বলতে হবে কোথায় page shown exhibit H টাই হ্যাঁ H টাই এবার PD 8 internal kindly come to shown exhibit H. Kindly come to internal page 6, first paragraph. Do you find that the last line of the first paragraph records that the property is sold to the purchaser for commercial use?
It writes here, but the purchaser also did see the sanction plan where it was very clearly written as a domestic use. So, sir, I didn't understand the question. Only whether I've seen it or not? Yes, I have seen.
কি আনসারটা কি গেল?
What is the question?
Last line of the past tense records that the property is sold
That document?
Yes, the title deed.
It is recorded.
So it's a registered deed, sir. Yes.
It is
sir.
recorded.
Yes, sir. Yes.
Yes, it is recorded.
Yes, it is recorded.
Let the entire answer go.
কি
He
আনসার
has
আমি
also
তো
made some-
বললাম আনসারটা কি
Yes. And further, anything what you have stated?
Sir, I said that it's up to the authorities.
Okay. That is there.
একটু পড়ে দিন
না যাইনি আমি
যতটা গেছে পড়ে দিন তাহলে সুবিধা হবে না পুরো প্রথম থেকে ইট ইজ রেকর্ডেড ইট ইজ সিন হি সেড
Last question, answer.
where the purchaser is also required to sanction where it is
Person also required to see the sanction
then I think it at least
See the sanction.
sanction plan ঠিক আছে
Yes.
Yes. The encircle power. Kindly encircle in red pencil the portion in the internal page 6 of exhibit H.
Already exhibit.
No, that portion is the exhibit H. Take our exhibit. Na.
Already exhibit
Oh, then the document is my exhibit.
Document is totally
Then leave it. I withdraw the question. Take your Mr. Bhattacharya, do you recall of any suit filed before the City Civil Court at Calcutta in connection with the property in question?
There was a tenant suit, I do recall. It was against the owners.
There was a title suit.
Not title, sir.
Tenants.
There was a
Tenants.
tenant who had done some form of litigation.
there was a tenant who had filed some form of litigation
Which was taken care of by the owner's lawyers.
Were you a party to that suit?
I don't remember, sir. It was the owner's responsibility to give me a clean title, which they did after removing this suit.
If I suggest to you that you were arrayed, you know the company that your company নামটা দেখি that Exclusive Homes Private Limited, represented by you, was made the defendant number 2 in the said suit?
Probably, sir. It was too long ago. I don't remember. But it was primarily sorry.
Probably. Yeah.
The owners took care of the suit. This much I remember. It was a long time back. It was 2008 or when was it?
Did you execute any vakalatnama in favor of any advocate to contest the said suit in the said proceeding?
Must have. If we are a party, we must have executed a vakalatnama.
We are a party. We must.
Are you aware? Yes. Are you aware what happened to that said suit?
No.
You could aware? I'm showing you. No, Kiko is not aware. That's the difficulty. No, I don't have a certified copy of the. That is the difficulty. They don't have a certified copy. Okay. I'm showing you a certified copy of an order number 63 passed in title suit number 715 of 2011 in the City Civil Court at Calcutta, 9th bench.
Sir, is it part of the exhibit?
There's no point in objecting to this, but because it's a certified copy, I can look at it. But Milord, we were expecting that we always followed that if there is some new disclosure.
Notices to be.
It is, Milord, to be.
Could have been given.
Even the email, Milord.
Can't it be a refreshing the memory?
No, that's correct.
It can be.
Refreshment
It's
of
a certified copy. It's correct to give the copy to them.
this question, it is not about what is there in the record is there. Witness cannot be tutored. No answer can come, Milord, which is fresh or which can be better. But it is only that if we get a copy of it, even the witness can have a look at it before he answers. And it can expedite the process.
Right up. To be very honest, yesterday.
No, similar issue has came before this court, before the commissioner. The same issue was come. One document was produced. That was a commercial suit, and the witness has given answer to that. Then the party wanted to exhibit. It was exhibited. Then objected. Then it has come to me.
Then Dhruva Ghosh came in and said,
We were doing some research in chambers as well on that.
No, only commercial is only confronting. Only way of confronting, and confrontation has a limit also. Cannot be open-ended like confrontation. But in a non-commercial, it's.
We request Mr. Mithul Anand, senior advocate, has given us this document. Let us go through it. He can reserve questions with this.
That can be. I know because it is only I also said yesterday night only, but
okay, no problem.
I will not.
Yes, next.
আমি এমনি তো শেষ করছি না না একটা কি বলার ছিল আর কি বলবো বল ওটাই বল আর বাকি সাজেশন হয়ে গেছে I suggest to you that the power of attorney issued in your favor is an invalid document.
I deny.
But let these questions remain for today. Only left suggestions has been all given. This certified copy and nothing more.
Nothing more.
Nothing more. 10 minutes maximum. 10 minutes. And even a certified copy, that's the only thing. Nothing.
How many witnesses you are having further?
No, he is the sole witness.
So last.
Then you will adduce.
No, I have done yes, the argument.
It would be for argument.
It will be for argument. It will be for argument. They will start.
Please step down.
Whoever starts after the
whoever for the plaintiff, so suffering for the defendant. Dependent witness is present. Cross-examination resumed. During his cross-examination, one document is marked as exhibit I. Other कुछ हुआ नहीं. खाली एक document exhibit हुआ तो. One full stop. Cross-examination is deferred on the prayer made by the counsel for the plaintiff. Full stop. Case is adjourned. Let the matter appear.
Any 22 এপ্রিল খালি দেবে না No.
Change karo
Other than 22nd April, any day.
Please change karo.
Refresh the
7th April at 3 p.m. 7th April 3 p.m.
3 p.m. 7th April.
Remarkable. Remarkable.
Comment?
7th of April is remarkable.
Commenting on judge's diary.
No, because of the change of determination. Now the total diary has been upset.
It's very relieving for us.
Because you got the space in the PLA matter.
Okay. वो থাকবে না সাথে বলছে whatever
साथ नहीं होगा
11th কটা বলছো
11th হ্যাঁ ফ্রাইডে আছে
11th না তিনটে হবে না গো তারপরে করো না সার্টিফিকেট কপিটা আনতে হবে সিডি কোডের আমাকে that's my difficult ওই after the 18th that
22nd April
8th করে দাও 8th করে দাও
नहीं उसको प्रॉब्लम मित्रा is having problem on 22nd
एपल साइन 9th
अभी एपल साइन नहीं है वो तो चला गया होगा ना कोई एक तो कौन सा नहीं असाइन नहीं है असाइन है नट असाइन है छोड़ दो ठीक है छोड़ो
30 30th at 3 p.m. 30th is already a matter আছে তো ওটা অ্যাসাইনড আছে কেজরিওয়াল yes Kejriwal is assigned to the court. It's only my assigned. That is assigned. No, তিনটে আছে ওটা মানে we can keep it. Mr. Chaudhary said only small time we can make it 3:30 or 3:45. No.
Not to take risk.
No. বলো দাও PA that PL is assigned. যাবে খুশি দাও
কাকে বলছো ডেভিড
কাকে বলছো 7th May ঠিক আছে oblige
at 3 p.m.
oblige চাই একটু লম্বা হয়ে গেল ঠিক আছে যাক চাপ নেই সার্টিফিকেট কপি না oblige 7th May at oblige
7th May कौन सा
item 12 Mr.
है कॉल वो रखो बाद में पढ़ लेंगे
For the defendant number 10.
Yes.
I appear for defendant 6 and 7. Mr. Bose is on his way. I can start, my lord. Yes. We'd already indicated to my lord the factual submissions. We'd already indicated, my lord, this just to remind, my lord, we're seeking vacating of the order of injunction passed by my lord on 10th May 2024, whereby my lord had already granted an injunction restraining my clients from operating his bank account so far as the unliquidated damages claim of the plaintiff are concerned. My lord, Mr. Bose had indicated on the last occasion, my lord, one of the main submissions advanced by Mr. Thakkar was that the purchase orders that's been disclosed by my client in the affidavit in opposition, purchase orders and the invoices of sales made by my client to D1 are inflated. They are above the index price. The word used by Mr. Thakkar was index price. My lord, we've checked up the charts that's been shown by Mr. Thakkar before this honorable court, my lord. They correlate the prices indicated in the purchase orders and the invoices with data that is available publicly on the Ministry of Commerce websites. There is no regulation or limitation on sale of these commodities. These are free trade commodities. We've taken instructions, specific instructions from our client. These are free trade commodities that are traded in the open market by our clients. There is no cap set by the government, either on customs duty or otherwise. Therefore, that argument perhaps will not really lie in the mouth of the plaintiffs. Whatever price I have sold to the defendant one, is an independent price. It does not concern the D6. We will now kindly have a look at the judgments that's been placed. We will kindly have a look at 1951 King's Bench. that's been cited by Mr. Thakkar. We are only to distinguish the judgments, my lord. We're almost done with our submission. My lord has 1951 KB. That's 1951 King's Bench, Division 854. Case of Shankling here.
1951.
1951, my lord.
Yes.
My lord, in this matter, my lord, we'll kindly have a look at this order. This is, my lord.
Before my learned friend begins with this judgment, your lordship will kindly mark this matter part-heard, my lord.
It's already part-heard. Already.
And this is a commercial, na?
Yes, commercial, nothing else.
The commercial.
And my lord, this is also part-heard. This is the first, I believe,
Even though
adjournment.
not commercial, it is a commercial matter.
It's a commercial matter.
Commercial
Commercial
is-
division is fully.
The total commercial is here.
Then
Not other than commercial, I can't take
I
it.
was given an impression that everything is.
We all sighed some relief after we came to learn of that commercial detail.
Yes, yes, absolutely.
Only I have been given the commercial and company.
All irrespective of years, all years.
All years.
All years. And this is part-heard. And this is in any event, my lord.
That's why the testamentary peoples are mentioning.
Then that's okay.
My lord. My lord,
So I cannot keep all matter. Some other judges should take care.
But everybody from the bar would want. But whatever.
Yes.
Yes. My lord, 1951 King's Bench and along with a 1965 Queen's Bench. I'll come to that later, my lord. 1951 King's Bench. These are trial court decrees. These judgments, my lord, will kindly see the operative portion of these judgments. These are trial court decrees that have been passed after analysis of evidence. That is also evident in this case, my lord. My lord, we kindly take page 855. 855 bottom, the second last line. His lordship reviewed the evidence about the negotiations which led to the acceptance by the plaintiffs of the two costs of so and so. These are all cases that have been cited by the plaintiff to show that claims on account of collateral contracts can also be maintained. That is the sum and substance of the reason the plaintiff cited them. All of these judgments, my lord, relate to judgments and decrees passed after trial, after evidence. These are final orders. Today we are at a different stage, my lord. Today we are at a stage where only a prima facie case has to be shown by the plaintiff without going into trial and evidence.
Yes.
I have still not been afforded an opportunity to face trial, to face cross-examination, to lead my own evidence. The plaintiff will have to prove its case in respect of the unliquidated damages. My lord, I'm being led by Mr. Bosman.
So, well, these three judgments that my learned friend relies upon, well, in our respectful submission, has no manner of application in the facts of this case and at this stage, because all the three judgments are post-decree situation, and in the pre-decree situation, my lord, this issue, what has been decided and for the purpose for which these judgments have been cited, cannot be any manner of application at this stage. Well, your lordship will also kindly consider one thing. Whatever they have said, or whatever they try to contend so far as injunction attachment, or based on the case made out by us is considered, these are all manner presumptions denied by me in my affidavit. So now the only option for him is, if the suit survives,
Prove the evidence
in the trial.
Okay.
So it can only be proved in the trial, because, my lord, your lordship knows evidence. These are all affidavit evidence. My lord, Mr. Thakkar had said that, my lord, I'll just take out my note. This is not my brief. Lordship kindly gives me a moment. Take this, take this. Yes. The note the note that we had given it to them. Yes. Preponderance of probability to establish fraud in a civil suit. How would that remotely be applicable at the facts of this stage? Now, my lord, their case of fraud, I don't wish to repeat, my lord. I have already said, my lord, I am selling my goods to defendant number one at a price which, according to them, is more than the index price. Number one, my first contention is this was not the case made out by you in the interrogatory application.
Correct.
Now he says that he has made out the case based on the invoices that has been that he has come to know from me. Now, if your lordship will see the difference, at the time when he filed the suit, he was aware, and his case is that I was supplying to D1. So that means you knew that I am supplying to D1. This is your case. Now I have said in my opposition, I have disclosed a set of invoices from which it will be evident that I am independently, based on my purchase orders given to by defendant number to me as a supplier and a manufacturer of that product, I have been supplying to defendant number one. Now, he says that these invoices are fraudulent. Now, whether they are fraudulent or not, that my first submission on that fraudulent part is that is irrelevant so far as you are concerned. Defendant number one does not say fraudulent, and the invoices are proper invoices with GST. And my lord, the only reason on the ground why he alleges that those are fraudulent, why? Indexation of price. Now, my lord, in course of that indexation price, my lord, they had also referred to something called the HSN code. Now, my lord, kindly have a look at what that HSN. If your lordship recollect that, allow me to, my lord, just clarify that part once. Your lordship is aware. My lord, in customs, even in GST, there is a classification of goods, right? Now, this classification codes are given to each kind of product. Well, if I may just take 30 seconds of your time, my lord, there was a matter in a customs matter, but there was a big issue relating to betel nut, supari, betel nut. Lord, betel nut was 90% of the betel nut are imported into India because betel nut in India is very expensive. So they mostly come from Malaysia and these Southeast Asian countries. So there was a exemption notification issued by the government of India for the purpose of import of that betel nut. Erica is the word, the scientific word of betel nut, Erica betel nut. Now, there was a particular type of betel nut for which the exemption notification comes. If the betel nut is in that condition, dried, this, unprocessed, then, so now in order to get to avail the benefit of the exemption, well, the entire Erica nut, which is of thousands and thousands of crores worth of Erica nut, has been processed through Bangladesh. There's a bilateral agreement between Indian government and all that. So customs authority, they assessed the goods in the bill of entry under a different HSN code. They said that no, these betel nuts don't form under this, but they form under HSN code number such and such. So the exemption notification is not applicable. So you have to pay 20%
of the tax,
IGST and tax. So that becomes unviable. So that was under challenge. So based on that, my lord, your lordship will see product by HSN code is given. Now what they are trying to say is that there is a HSN code in the tax invoices which we have disclosed in our affidavit in opposition, and Mr. Thakkar says that the HSN code that is there in their purchase order or their products are also the same. It has to be the same.
But the code is...
Because if it is the same product, it has to be the same HSN number. But kindly give this to the judge. কি বলছে ঠাকুর, কি বলছে? বলো, ব্যাগ দেখিয়েছি তো। না তো তুমি HSN টা তুমি তাহলে, are you giving up the HSN part? তাহলে ব্যাগে চলে যাবো। Malad, kindly turn to, have you given this page? Malad, this is schedule 10, base metals and articles. So we've just given that metal part. Now if your lordship will kindly turn, এই পেজটা খুলে দিয়েছো? Malad, kindly, if your lordship will see code 7202,
yes,
ferroalloys. So these are the list of ferroalloys. They get a copy though. My lord, kindly take ferroalloys.
That's why yesterday we had a meeting of the commercial court. So we propose in every field the expert is to be appointed.
Correct.
So that the court can get the support of the expert also.
Absolutely. Absolutely. Even our section 26 of the Arbitration Act also says the tribunal can also suo motu ask for. Yeah, it is not possible for a member of the judiciary or even for members of the bar to know everything. At least we get the benefit of the inputs from the clients.
Yes, they deals with that.
Correct.
Then they explain. Then we have to search.
Right. Correct. Well, this is also we've also derived this from an expert. So when kindly see under ferroalloys, your lordship will find containing by weight more than 2% of carbon, that will be category 7202. The lordship will only consider the last 4 digits, 1100. Then my lord kindly see if it is any other, then it is 1900.
Yes.
Then ferrosilicon, which is our product, your lordship will see ferrosilicomanganese. There are 2 separate codes.
Yes.
Containing by weight more than 55% silicon is one, then other is this, and then ferrosilicomanganese is 3000. 3000. So, my lord, in our invoices, your lordship will see there will be 2 HSN code. One is 1100 and 3000.
Correct.
Because the materials which we have supplied, they fall into these 2 categories.
Yes.
So this corresponding HSN code I have given. Now, if I give a wrong HSN code, then the custom will say misdeclaration.
Fine.
No, there is seizure, confiscation, show cause 124, and then the other situation will start if you make a misdeclaration. So misdeclaration, they are entitled to give me a show cause for misdeclaration. So now, if your lordship will kindly see. Now, my lord, if your lordship will see, now their bags, what they are trying to say, their bags, HSN code is there, your lordship will see.
Page number?
This will be page number. Reply. Their reply page 42. All I am trying to say is, my lord, this photograph, their bag, it has the same HSN code. It has to be, if it is ferrosilicomanganese, whether the manufacturing is X, Y, Z,
the number will be same.
Number has to be the same.
Because that code can be used by
anybody.
That product.
It has to be used for that product. Now, it's like, say, suppose a television. Now, the television, whether it is sold by or it is manufactured by, my lord, Sony, Samsung, LG, Toshiba, the HSN code will always be the same. Now, as an example, if your lordship will see any other product, if your lordship just turns the plate, because we've given the metal part, which is chapter 15, if your lordship will turn to anything, like your lordship will say, like pickles, the very, very, very controversial item in custom, pickles. Because the moment you add certain ingredients to the pickle, it goes under a different HSN code. Now, herbal products, your lordship will find, I'm just giving an example. Herbal products, your lordship will see, if the content of the herbal, the ingredients of herbs is more than 55%, one category. If you adulterate it, immediately it goes on to another category. Then it goes into the category of medicine. So the rate immediately goes up. So HSN code is basically on the basis of HSN code, the rates, the tax, the impositions are, the levy is based on the HSN code. So, my lord, my learned friend's argument, so far as HSN code, and my lord, to correlate the HSN code, to substantiate that the products that I have been selling to defendant number 1 was in fact meant for him, well, that is in my respectful submission fallacious.
Yes, next.
Now, my lord, I'll just HSN PO 79. My lord, one just page, if your lordship has the opposition once. Page 70 of the opposition, if your lordship, much has been said about that. that SGS report, that inspection report your lordship recollects, SGS inspection, that they said that SGS went to my factory. Since SGS went to my factory to take an inspection and the container numbers are matching with the container numbers there, so I knew that the money that they were paying to defendant number 1 was in fact for supply of materials by me to defendant number 1, which in turn will defendant number 1. This is the hypothesis. Now, my lord, kindly take once my opposition. If your lordship will take any page, which is any of the purchase order, kindly take page 79. Your lordship will find page
79. Yes.
Yes. Now, this is the purchase order issued by me, issued by, I stand corrected, defendant number 1 to me, because I am the supplier, they are the purchaser. They issue the purchase order to me so that I supply to them. Now, kindly see at the bottom of the purchase order, your lordship will find the terms and conditions. And kindly see terms and conditions, serial number 2.
Third party inspection to be done by SSG, Kolkata.
So SGS is the common inspecting agency. In these kind of product, in fact, in the industry, SGS is one of the principal inspecting agency. So just because SGS came to my factory,
yes,
that necessarily does not mean
yes,
that they had come to inspect the goods that were required to be supplied to you.
yes.
Even the contract between me and defendant number 1 also has SGS. So when I allowed, even if your lordship assumes when SGS came to my factory, even if they have come to my factory for the purpose of inspection, so that they have come based on the purchase orders issued by the defendant number 1. All my purchase order has SGS. So you cannot.
So is the common body.
Correct. So that connection that they are trying to create, since SGS came to my factory, I knew that my materials were going to them.
Yes.
This is in addition to my previous submission that whether my material was finally given by defendant number 1 to you, that is irrelevant so far as I am concerned, because that cannot concern me. If he has chosen to sell it to you, that is between you and defendant number 1.
Not connected.
I have given it to them. SGS, even if they have come and taken inspected, they have taken inspection based on the purchase order and the understanding I had with the defendant number 1. Now, my lord, your lordship will kindly take. My lord, they had shown a letter in course of argument saying that they had sought for inspection of these invoices. And we wrote a letter saying that this is not the stage of inspection. I will give you inspection at the relevant point of time. And then, my lord, my learned friend referred to, my lord, order 11 once. My lord, there order 11 from the Civil Procedure Code and then order 11 from the Commercial Code Act. But since it's a commercial suit, my lord, kindly take the Commercial Codes Act once. Your lordship will see the amended provisions of order 11.
Yes.
Under the schedule, which is in reference to section 16 of the Act. I will kindly take order 11, rule 3. Order 11, your lordship, is a disclosure, discovery and inspection of documents. Then, my lord, kindly take rule 3. Inspection.
Yes.
Rule 3, your lordship will find inspection.
Yes.
Well, the subsection 1 of rule 3 relates to complete inspection of document disclosed within 30 days from the date of filing of the written statement. Now, my lord, kindly take sub rule 2. Any party to the proceedings may seek directions from the court at any stage of the proceeding for inspection or production of documents by the other party,
yes,
of which inspection has been refused by such party or documents have not been produced despite issuance of a notice to produce. So his right under sub-rule 2 is to seek directions from the court. So you have to apply for seeking directions to the court that you have not done. Now if your lordship will kindly come to sub-rule 3. Order in such application shall be disposed of within 13 days. Now my lordship kindly comes to 5. No party will be permitted to rely on a document which it had failed to disclose or of which inspection has not been given, save and except with the leave of the court. So this is the eventual final consequence. I will not be allowed to rely upon the document. Yes. So this situation will also arise, though it says at any stage you have to make an application. Otherwise, at best, adverse inference, nothing more than that. So, my lord, this is purely a point of prejudice, nothing more than that. And my lord, while commencing the argument, they referred to the juror portion of their affidavit in opposition to suggest that the person who has affirmed the affidavit is not authorized because he is a constituted attorney. Now, my lord, when we filed the Wakalatnama, we filed the affidavit of competency within the Wakalatnama. I have taken specific instruction. We have a copy of the affidavit of competency as well. That makes him competent. Now, the question, he says that there are certain pleadings which is affirmed. He could not have had personal knowledge of those pleadings. Now, my lord, in the interlocutory stage, look, this is of no consequence at the interlocutory stage. So at the time of trial, if you have to prove your case. If that is one of my defense, then I have to prove my defense. So now, my lord, whether that person had the authority to affirm that portion of which he did not have personal knowledge, it may not be of much relevance at this interlocutory stage for the purpose of consideration of the grant of injunction or attachment. So, but these are my. Kichu baki ache? Bolo bolo.
That's sir.
Case gulo ar kichu ache? Now, my lord, there's one last judgment that my learned friend has shown. I'll just take 30 seconds of your lordship's time. That 2023 Tata Motors. My lord, kindly take 2023 SSC Online SC 638. Which my learned friend relied upon in support of his contention of collateral contracts. One paragraph, the rest I'll leave it to you, lordship. 2023, there was a judgment my learned friend had relied upon. 23 SCC, it is Tata Motors versus Deputy Commissioner of Commercial Taxes. 2023 SCC Online SC 638. SCS. SC না তুমি SCC অনলাইন দিয়েছি হ্যাঁ এটাই দিয়েছি So lordship got that. My lord, we are carrying extra copies. If your lordship wants, we can give it. Because your lordship had marked the portions that Mr. Thakkar had relied upon.
I will take.
Now, my lord, kindly take once paragraph 5. Kindly take the first page of where the judgment starts. Justice Nagaratna's judgment. Para 2. Then, my lord, kindly take the preface. There's a heading called preface, and then, my lord, there's a para 5 over there. Yes. Kindly take that, my lord. Well, this was a reference. So, my lord, the reference order, kindly see para 5. Thereafter, under para 5, there is para 15. That one. We are not delving into the controversy in any further detail, as we are of the opinion that the issue raised is required to be looked into by a larger bench. The crucial point which would arise for consideration and over which the matter needs to be debated is as to whether, well, this is where it starts, in the case of such a warranty for the supply of free spare parts, once the replacement is made and the defective
part is returned to the manufacturer, sales tax would be payable on such a transaction relating to the spare part based on the credit note which may be issued for the said purpose. This is in context of the observation discussed aforesaid regarding the price of the car being inclusive of the cost of the spare parts, the latter being supplied by for free upon replacement. Sales tax on a car is paid. Sales tax on the inventory purchased by the dealer is paid. Thus, if there is no consideration for these replaced parts, can sales tax be levied at all? See, if your lordship recollects, I gave your lordship an example of a Maruti dealer selling cars or any car dealer selling cars where the manufacturer stands by way of a virtue of a collateral contract. He gives a warranty in respect of a transaction between the dealer and the customer. Correct. Well, so now here was the issue about the sales tax part. So, my lord, here in our case, my lord, this collateral contract concept has no manner of application. Yeah. So these are my respectful submission, because your lordship is saying from the beginning, I have been saying, based on, my lord, the first judgment that we had shown, that, my lord, the entire claim of his is based on a claim for damages, and we had relied upon first judgment Raman Iron Foundry. My lord, I'll just conclude by showing one paragraph of the appeal court's judgment. Kindly, I'll just trouble you. It's already there with your lordship. My lord, when we went up in appeal. Yes. My lord, kindly take internal page 3 once. Internal page 3. Yes. Prima facie. It seems that the plaintiff has not disclosed any document to show in writing that the defendant number 6 has assured to supply the required materials to the plaintiff through the defendant number 1. However, there is a pleading of such assurance held out by the defendant number 1 to 6 jointly and severally. In absence of any document covering the contract period, it needs to be assessed whether the defendant number 6 would be restrained to operate the bank account to the extent of 18 crores. Well, this is the value to which my account has been attached. Mere verbal assurance without anything else may not be sufficient to pass a drastic order in the nature of injunction and attachment unless it is supported by nature of pleading, transactions, and conduct. By reason of the order of injunction, the defendant number 6 is unable to operate the account. The plaintiff is unable to show exchange of correspondence between the plaintiff and the defendant number 6, by which the defendant number 6 can be held to be responsible for non-supply of defendant number 1. If the defendant number 1 has received the money, it does not automatically follow that the defendant number 6 would be obliged to supply the materials to the plaintiff through the defendant number 1. However, it is alleged that the joint inspection was taken. Unless a strong prima facie case is made out, then, my lord, it can be said that that some amount of certainty at the interlocutory stage that the defendant number 6 is all bound by the contract, and the defendant number 1, it may be unfair to restrict the defendant number from operating the account. But anyway, my lord, since we did not file our opposition within time, we suffered the consequence. Because there was a direction of your lordship to file affidavit, we did not. So that question fell from the appeal court, so the answer was naturally no. So these are my respectful submissions.
Yes. Appearing for the defendant numbers 11 and 12, I would also like to supplement Mr. Bose's argument. Not more than 15 minutes. Your lordship can be assured that I will not repeat any point. Only the points of distinction and 2 additional points I will submit. Because according to me, although I'm also a manufacturer who is similarly situated, but my degree of nexus, my degree of involvement in the process is even lower. So your lordship will kindly allow me, I will be very brief. Your lordship will kindly give me 15-20 minutes on any day. And I will not repeat any of the points.
So suffering for the plaintiff, suffering for the defendants are देख लेना इसमें कौन-कौन defendants. Police counsel for the defendant number 6 and 7 has concluded his argument. Police counsel for the defendant number 11 and 12.
11 and 12.
11 and 12 submitted. Press for time. Submitted. He press for time to argue the matter. No, it is in council for the 11. But first, let the 6 be completed.
Was it comments to your lordship? I was only wondering if I can also make my point. Mr. Thakkar can perhaps deal with it in a consolidated manner.
Because there is a direction of the
Yes, of the appeal court for the respondent number 6.
appellate court.
That's a problem.
Then if I will allow you, then all persons
All
will
will
come.
come.
Then.
My only submission is I completely leave it to your lordship as it comments to the procedure of court. My only submission is if I add a point which is in the line of the same argument, then that entire repetition and another round of hearing perhaps would not detain your lordship.
And Mr. Thakkar, how much time will take?
15 minutes. I will take 15 minutes.
Mr. Thakkar will. This is a 15-minute matter. Nobody has said 10 or 20.
My 15
Everybody
minute
wants
can be-
15.
Might be different from Mr. Bose's
Can you
15
fix the date,
minutes.
my lord? Any date which is convenient, my lord?
Concluded this argument. Full stop. Counsel for the defendant number 11 and 12 also intend to argue the matter. Full stop. In view of the above, case is adjourned. Let the matter appear on.
Normally, your lordship only has commercial. So now your lordship.
He had
we
the
got
benefit of
commercial.
that today in the morning.
I don't know.
Commercial.
Only commercial.
2nd April. 2nd April.
Very well. Could it be on the 3rd, your lordship, subject to your lordship's convenience? 3rd.
Third khali hai.
So let 2nd April, let Mr. Thakkar respond to my, and then that finish, let him come on the 3rd. No, to me 3rd
3 p.m.
Thakkar
2nd
bole
April,
diye
3
আমার
p.m.
you come in 3rd.
Very.
2nd April.
3 p.m. 3 p.m.
There's a fixed matter. Both Mr. Gupta and I in a fixed matter, which is at 2 p.m.
It is 3 p.m.
That will not get over.
Not over.
Can you make it 3:30, my lord? We'll come.
My lord, Mr. Thakkar doesn't do 1 hour matters. He doesn't.
Yes, match.
Well, can you keep it at 3:30, my lord? Because all three of us, in fact, I would not have made this request.
7th April, 3 p.m.
Yes, grateful.
Very well.
7th আমরা নেই। ঠিক আছে তোমরা
Interim order is still the 8th, so we'll pray for an extension.
7th. Very well. I'm deeply obliged.
7th April বলবে?
7th.
ঠিক আছে ঠিক আছে 7th তো মানডে। হ্যাঁ
Yeah, evidence.
Yeah. My lord, Mr. Thakkar, my lord, 7th April, I was just informed that, my lord, there's a 3 p.m. matter which I have before courtroom number 36 at 3 p.m. only.
Let they argue then.
Very well, very well, very well. Mr.
Your juniors
Very well,
will
very
be there.
very.
Your junior makes excellent notes, even better than my juniors.
Yes.
Well, today I was supposed to start the arguments.
The special assignment. Special assign है क्या?
Specially assigned?
नहीं है. गया.
In this matter, I have
My lord, I would beseech you, এটা বোধহয় specially assigned কারণ ওই কোর্ট থেকে এসে দেখুন তো। My lord, I would, but your lordship had heard it only 1 day or 2 days are, my lord, your lord, once this has happened, one court from one court again we had to start de novo. My learned friend has completed his argument. It is my turn to, our argument had started. Today I was to continue with my argument.
And in the meantime, I have also filed an application.
Well, whether that application is maintainable or not, that is a different question. We shall come to that. And only I have started my arguments, a bit of it is left out.
Yes.
I have filed an application.
What application, sir?
But at this stage, application.
G number 9. I have prayed for
G number
9.
G9.
G9.
What the application you filed?
That is, I have prayed for a forensic examination of the signature of the testator. Because if one can see in open eyes with the admitted document and the disputed document, if one can see in open eyes, he can understand that signature is totally different. And from the very beginning, the defendant herein repeatedly submitted to this court that this is otherwise a forged will. In no material points of time, the testator has executed any such kind of wills. Repeatedly, the defendant submitted to this court at the time of adducing evidence and from the very beginning, affidavit in support of the caveat everywhere.
Correct.
That is why I have filed the
So,
application.
they have disclosed their defense at the time of filing of the affidavit in support of caveat. Correct?
Yes.
Thereafter, issues were framed.
Yes.
Evidence were laid.
Yes.
Evidence cross-examination was done.
Yes.
Case is fixed for argument.
Yes.
Can at this stage you can pray for sending the matter to, because suppose why I am telling is this court, even expert report cannot be relied upon. It is not a conclusive report. Expert report cannot be treated as a conclusive report. Expert report can be treated as one of the circumstances to connect with the evidence. Now evidence is so.
Yes.
Today, if this application will be allowed,
yes,
what will be the effect? The report cannot be taken into consideration as it is in the record.
Well, all these are technicalities.
Not technicalities. This is the point which stage the application is to be filed for the forensic examination. That is the question. If you telling that the other party is taking the benefit of the signature, it is your duty who has challenged for sending it to the forensic, because forensic report automatically, suppose the court allow you to send it to the forensic report.
Yes.
It sent to the forensic report. Report comes. Whether the report this court can take into consideration of the report directly, or what procedure is to be adopted.
Whatever positives is to be adopted, it will be adopted.
No, then evidence. How at the time of argument evidence can be led?
Then the matter can be shifted back to evidence stage.
Why? That's why that cannot be.
After completion
That
of my
cannot
learned
be at the
friend's
time of
argument.
after the completion of the argument. After the completion of the argument, no court can call for the evidence of any of the parties.
Evidence has not yet been concluded.
Evidence is not concluded.
Argument.
Maybe that's why argument is started. One party has concluded his argument. I will not allow, sir. This is a misconceived application. And this is not the proper stage. You lost your chance.
At any
stage, correct.
Yes.
But not at the time of argument.
Otherwise, there shall be great injustice. There should a forged will cannot be allowed to be probated.
You continued to allow. You continued with that forged will, alleged forged will, till the argument is over. You have not taken any steps.
I have taken.
What steps you have taken?
In the evidence also repeatedly, the defendant as well as everywhere it has been submitted that it is a forged will. Just see the affidavit in support of the caveat and the defendant adduced evidence everywhere. She has adduced evidence.
That's why I told you. That's why I'm telling you. They have disclosed their defense at the time of filing of affidavit in support of caveat.
Yes.
You had the knowledge they're challenging your will, signature.
Yes.
Correct. So you have not taken steps.
Not my will, it is their will.
Their will. What you have taken the steps, and they continue with you. If you are challenging, so you could have been taken the steps at the early stage. You have not taken that. And even though expert report is not the conclusive report,
even after conclusion of arguments, if the court thinks that
Okay, I will allow I will pass an order. You so I am
Lordship will
disposing of
hear
this.
me out before passing an order. Before passing an order in this application, your Lordship will hear me out. Because this will go higher up, I want to put in my defense. My lord, my learned friend today is asking for an order to get an expert report. My lord, all three witnesses produced by the plaintiff were cross-examined by my learned friend. My learned friend has
You will
failed.
file affidavit.
No, my lord, this is a misconceived application. I only wanted to indicate my part of the points I would like to highlight before your lordship. My lord. My lord, all three witnesses, the propounder, the attesting witnesses, both the attesting witnesses had come to the box. They were cross-examined. My learned friend, there is not one single question put to them in cross-examination from where whatever my learned friend has submitted before your lordship will appear. Thereafter, my lord, my learned friend has produced that document. He did not disclose his documents. It was produced at the stage of evidence. My lord, it was open to him to come up with an application. He failed to do so. His witness came to the box. There is nothing on record. Firstly, in the affidavit of in support of caveat, nothing. The witness had come to the box. The witness has also failed to make out a case. Even though, my lord, your lordship knows what is not there in the four corners of the pleading, any amount of witness evidence cannot be looked into, apart from what has been pleaded. Now, then also my learned friend has failed to make out a case. It was open to my learned friend to come up with an application. At that stage, he failed to do so. It was he who started the argument. After the evidence was, trial was closed, and thereafter evidence started. My learned friend has made his submissions. There is an order passed by your lordship that his evidence is, his arguments are complete. Thereafter, we had started our arguments. But at this stage, he comes up with this application. This is just a dilatory tactics.
At the time of argument also, I have submitted.
My lord, can such submission be made at the time of argument?
Yes.
Is that the stage? It was open to him to come up with an application before the evidence was taken down. He did not do so. He chose not to do it. He has issued, Shopina was issued to the custodian of the will. He had examined that person. What stopped him from coming up with an application at that stage? He did not do so. Now, my lord, if your lordship takes up the affidavit in support of the caveat filed by my learned friend. What is the case made out by my learned friend in the affidavit in support of caveat? Now, your lordship comes to page 3, paragraph 6 onwards. It would be pertinent to mention here, your lordship has got it. Pertinent to mention here that at no material point of time, the sad news of death of my beloved father was ever communicated to me by any of the present executrix or the so-called present will in question, for which the illegal and motivated grant of probate is now sought for from this Honorable High Court. Therefore, there are cogent grounds for not grant of any kind of probate or letters of administration as sought for by the present executrix of the purported will in question as per provisions of law as laid down under the Indian Succession Act. It would be further pertinent to mention herein that I came to know about the sad demise of my beloved father through an advertisement. Your lordship can skip that portion. As a paragraph 8, my lord.
Yes.
As a result of which I could not perform the sad ceremony of my beloved father, which caused immense mental pain and agony. Paragraph 9, be that as it may, I do hereby most humbly and respectfully state and submit before your lordship that the entire will in question is absolutely vague, untrue, false, forged and fabricated. All possible grounds taken. from its very first line, it is to its very last line. The signatures as well as the initials as depicted on the face of the so-called will are also absolutely false and forged. The so-called will in question also did not include the details of the other various properties duly owned by the deceased beloved father. My lord, may I pause here? What is the scope of a testamentary suit? A testamentary suit cannot be expanded by any stretch of imagination, my lord. It has to deal with only those properties which is mentioned in the will. The late such and such, who was none other than a, my lord, your lordship can skip this. The manner or the language in which the so-called will has been drawn up cannot be that of an eminent. That the so-called purported will is very much motivated, malafide, manufactured, purported, concocted from its very sum and substances. The purported will in question also does not bear the signature and the authentication of the person who drafted and typed and or explained the same to the testator as required under the statute, my lord. A person who is a literate person and a stalwart in legal profession, I don't think it was required to be read out and explained to him, first of all. Secondly, there is no such requirement for authentication of the person who has drafted it. The law does not provide for any such provisions. Since I am a tea planter by profession, now if I may pause here, my lord, this is the affidavit of a deceased person who is no longer.
Who?
The affidavit of the late Snehojit Sengupta. He was substituted by his wife. No amendment was carried out. Only her name was put in. So today, whatever has been stated in the affidavit cannot be her version. It was not amended as per the direction of the court. Only the name was changed. Since I am a tea planter by profession, the tea garden I work in is situated in the district of Jalpaiguri. I have no other option but to stay away from Calcutta. The testator was an aged person suffering from various ailments and senility and not in sound state of mind and body. Moreover, was fully dependent upon his wife, and my prolonged absence from home had given them the absolute liberty and opportunity to contrive against me and fulfill their sweet desires by putting undue influence, pressure, and coercion on the testator. So now, first of all, he said it was false, fabricated, forged. If that is so, this ground taken by my learned friend that it was made out of coercion, undue influence, cannot come in. Now, he cannot have it both ways. Either it is forged or it has been procured by undue influence, and thirdly, that the testator was not in his proper state of mind and health to make the will.
Yes.
All possible grounds have been taken. Hence, in any event, no probate should be granted on the basis of the purported will in question in favor of anybody else, whosoever, including the present executrix of the same. The property or properties duly left behind by my beloved deceased father, namely late such and such, should be divided and or distributed in accordance with law as per Hindu Succession Act, as if there is no existence of any kind of will or codicil purportedly left behind by my beloved deceased father and late Ajit. Now, that is all. Mere bald allegations, unsupported by any cogent evidence, reason, or documents.
Yes.
And nothing was brought on record from which the allegations brought forward by the caveator could be established. There is not a single document. Now, on the contrary, the propounder has proved the will by adducing evidence of two persons who were the attesting witness. My lord, the law requires only one attesting witness to come to the box. Both of them came to the box. Both legal luminaries came to the box and they were offered themselves for being cross-examined. They were thoroughly cross-examined by my learned friend. And my lord, I shall place today, there's no lack of time, my lord, but I would like to place the evidence which is crystal clear that my learned friend has not been able to demolish any of the positive statement given by them during their examination in chief. So, my lord, today this application, it is merely to put a spanner in the wheel because they are fully aware that they have been failed to bring out a case as sought to be made by them in their affidavit in support of the caveat, my lord. My lord, they had issued subpoena to another legal person in whose custody the will was there.
Original will.
Original will, which was kept in his custody. My lord, that person also came to the box. They, upon subpoena being issued by them, he came to the box. And at their instance, and from his documents, letters exchanged between him and the advocate of the defendant, my lord, the entire scenario is crystal clear. They were aware of the will.
So this will you have not filed along with the original?
Yes, yes.
So which will they have called for?
The initially after the will was prepared by the testator, it was kept in the custody of a lawyer. And after his death, the executrix was not aware of the existence of the will. After his death, she was intimated by such person that there is a will left behind by the testator and it was handed over to her. That person was called to the box also and thoroughly examined by my lawyer. He was his witness. He has issued subpoena to that person. My lord, I would like to take your lordship through the entire evidence. Okay. Today, this application is totally misconceived. At this stage, they cannot come up with this application.
Okay.
And your lordship had passed an order on 13th of January, my lord, where it has been recorded. The counsel of the defendant has concluded his argument and submitted that he will file written notes of argument in course of the day. And on that day, the written notes was also filed, my lord, after the matter was over. 13 January, my lord, I have a copy of the order. So today my learned friend is saying that he has not completed his argument, my lord. That is not incorrect. It was order was passed in his presence and subsequently he has also filed the affidavit, the written notes on argument.
Yes.
It was forwarded by a forwarding letter to my advocate on record after completion of his argument, my lord. But only thing that now remains is that I have to take your lordship through the evidence that was recorded.
So I will your application will be kept only. I will decide along with the total final argument, final hearing.
One of the attesting witnesses, he adduced evidence that he has put his signatures at the residence of the testator.
My lord, this is all on record. He has cross-examined.
Okay, that's why.
His argument is complete.
Other address.
Correct. Your evidence is concluded. Correct. Yes. Your argument is concluded. You file the written note. Then you file this application. I am
at that time also I have filed that application was already filed.
Correct.
Listed.
I am keeping this application on record. I will dispose of the total suit along with the.
Deeply obliged, your lordship. Lordship will fix a date. Short date though.
When suffering for the plaintiff, when suffering for the defendant.
My lord, your lordship will make it parted also. My lord, only one day's argument will be left.
The plaintiff has filed, the defendant has filed an application being GA 9 of 2025, praying for sending the impugned will for and to handwriting extract. Counsel for the plaintiff has raised objection. This could find that the defendant has already argued the matter and filed written notes of argument. Subsequently, the defendant has filed the present application. Full stop. Counsel for the plaintiff has also argued the matter in part, but hearing could not. The argument on the side of the plaintiff could not be completed. Considering the above, this court is of the view the application filed by the defendant, being GA 9 of 2025, can be taken up for final hearing at the time of final disposal of the suit. Let the GA 9 of 2025 be kept with the record. Please the matter on 2nd April
Deeply obliged, Your Lordship.
3 p.m.
For time.
2nd April 3 p.m.
Lordship will make it parted also, otherwise.
Parted.
Deeply obliged.
Yes.
Kindly don't take me miss for mentioning, my lord. My lord, the order yesterday, my lord, the injunction application that I moved yesterday around this time, it's not being uploaded, my lord. The difficulty is tomorrow is
Determination change by that time.
No, determination change now. It's effective from my lord, 1st of April.
You can get tomorrow. Today. I will
The postal is open till 6 o'clock.
send it. I will.
Tomorrow is Saturday.
Nah, just it will be uploaded.
My lord, my lord.
That's kindly item number 26 of the commercial list. The interim is expiring in 10 minutes. For extension of related
Item number
26 of the
Census suffering for the plaintiff. Where is the defendant? Nobody.
What is appearing with us?
Counsel for the plaintiff is present. He submits that the interim order granted earlier is going to be expired today and paid for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 1st of May 2025 or until further order, whichever is.
Similar prayer in item number 24, my lord. May I be permitted to mention one matter? That this matter has been heard before your lordship for a substantial period of time. Now, my lord, what has happened is we had already the applicant has concluded their arguments. Lastly, on the last occasion, lordship was pleased to record that due to paucity of time, the R5 respondent number 5 could not complete the arguments. Is it
What you want?
Maybe can it be parted, my lord, this matter?
How it can be? How can be? You can mention it is parted, kya?
No, my lord, it is not
Nahi hai na?
parted.
It cannot, no, this cat cannot then. You mention, Mr. Dutt knows.
Released from there and there.
Yes.
Similar prayer in item number 24, my lord, the interim order is expiring today.
So suffering for the plaintiff. Counsel for the plaintiff submit that interim order granted earlier is going to be expired today. Accordingly, prays for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier is extended till 1st May 2025 or until further order, whichever is earlier. Let the matter remain in the list.
Deeply obliged.
Interim order is still 2nd of April.
2nd of
Wednesday.
But come on Wednesday. It's a commercial.
No,
Non-commercial, I can't.
But take your lordship.
Today, but the 2nd April till, so I cannot take. 2nd April is when? Wednesday.
Monday.
Huh?
Monday.